warahmatullahi wabarakatuh.
Warahmatullahi wabarakatuh.
Ladies
Wabarakatuh.
and gentlemen, welcome to the 9th International Conference on Law Justice 2025. Alhamdulillah, Alhamdulillahirabbil alamin, wassalatu wassalamu ala asrofil anbiya wa mursalin, Sayyidina wa maulana Muhammadin wa ala alihi wa sahbihi ajmain. Amma ba'd. Good morning, our distinguished girls, esteemed colleagues, and participants from around the globe. The ninth International Conference on Law and Justice, hosted by the Faculty of Sharia and Law, UAN Syarif Hidayatullah Jakarta, in collaboration with University of Malaya, Malaysia. My name is Aida Korea. It is an honor to serve as your Master of Ceremony for today's conference. Before we begin, let me acknowledge our distinguished guests who honor us with our presence today. Our esteemed keynote speaker, Professor Dr. Haji Sunarto SH.MH, Chief Justice of the Supreme Court of the Republic of Indonesia, Rector of UAN Syarif Hidayatullah Jakarta, Profesor Asep Saifuddin Jahar MA PhD, Dean of Faculty of Sharia and Law, UAN Syarif Hidayatullah Jakarta, Profesor Dr. Muhammad Maksum MA MBC, Honorable speakers, Profesor Madya Dr. Siti Zubaidah Ismail from University of Malaya, Malaysia, Dr. Balwin Jones from La Trobe University, Australia, Dr. Ashraf Bulli from University of the Western Cape, South Africa, Profesor Dr. Amani Lubis LCMA from UAN Jakarta, and Profesor Dr. Mashkuri Abdillah from UAN Syarif Hidayatullah Jakarta. I would also like to acknowledge our Vice Dean who are joining us online today. Vice Dean for Academic Affairs, Profesor Dr. Mesraini SHMAG, Affairs, Dr. Afwan Faizan MA, and Vice Dean for Student and Corporate Affairs, Profesor Dr. Kamarusdiana MH. And to all heads and secretary of study programs, faculty members, and participants from various countries, welcome to today's conference. Ladies and gentlemen, this year, we gather under a compelling theme, Ethic in Action, Navigating Legal Integrity and Accountability in the Modern Justice System, a theme that resonates deeply in our contemporary legal landscape. Before we begin our formal program, let us take a moment to express our heartfelt gratitude to Allah Subhanahu wa Ta'ala for making the gathering possible. I invite everyone to join me reciting Basmalah. Bismillahirrahmanirrahim.
Bismillahirrahmanirrahim.
Thank you so much. Let's begin with opening prayer to seek Allah's blessing for our conference. I invite Dr. Haji Qasim Arsyadani to lead us in prayer. Dr. Qasim, the screen is yours.
Thank you. Bapak sekalian, Assalamualaikum warahmatullahi wabarakatuh. Mari sama-sama kita mulai kegiatan kita yang amat sangat baik dan bermanfaat ini dengan sama-sama kita hadapkan seluruh jiwa raga rasa kita memohon kepada Allah Subhanahu wa taala. Kita berdoa yang akan insya Allah saya sampaikan nanti mohon diaminkan. Ala hadhihi niyyah wa ala kulli niyatin shalihah ila hadratin Nabi Muhammadin sallallahu alaihi wasallam. Al-Fatihah. Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin. Arrahmanirrahim. Maliki yaumiddin. Iyyaka na'budu wa iyyaka nasta'in. Ihdinas siratal mustaqim. Siratal ladzina an'amta 'alaihim ghairil maghdubi 'alaihim waladdallin. Amin. Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin. Allahumma shalli wa sallim wa barik ala sayyidina Muhammadin wa alihi wa sahbihi ajma'in. Allahumma ya man huwa fi 'ulumihi kain. يا من هو في علمه محيط، يا من هو في فعله حميد، يا من هو في لطفه شريف، يا من هو في ذاته قديم، يا من هو في مجده منير. اللهم أكرمنا منك في نور الفهم وأخرجنا من ظلمات الوهم وارزقنا فهم النبيين وحفظ المرسلين وإلهام الملائكة المقربين اللهم يسر لنا أمورنا مع الراحة في قلوبنا وأبدان وسلام والعافية في دين دنيانا ربنا آتنا من لدنك رحمة وهيئ لنا من أمرنا رشدا ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين آمين. Makasih. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much, Dr. Qasim, for the beautiful and meaningful prayer. Ladies and gentlemen, we will now singing for Indonesia Raya and followed by the hymn of UIN Syarif Hidayatullah Jakarta.
Aku berdiri kebangsaanku, bangsa
Thank you so much, everyone. Ladies and gentlemen, now we turn to welcoming remarks. Please join me in welcoming Professor Asep Saifuddin Jahar, MA PhD, Rector of UN Syarif Hidayatullah Jakarta. Professor Jahar, the virtual floor is yours.
By team, maybe I am first with after that Victor.
Okay, thank you so much, Professor Maksum. Professor Maksum, the virtual floor is yours.
Oke, Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. All praise are to Allah, the merciful, whose grace and blessing have enabled us to gather in this ninth international conference on law and justice. Praise and be upon to our Prophet Muhammad sallallahu alaihi wasallam, his family and companion. Firstly, we would like to express our sincere gratitude to His Excellency, the Chief Justice of the Supreme Court of Indonesia, Dr. Sunarto SH MH. We still wait him. His Excellency Rector of UIN Syarif Hidayatullah Jakarta, Professor Asep Sarifuddin Jahar. May Allah grant health and prosperity to His Excellency. The Honorable Outstanding Speakers, Professor Madya Dr. Siti Zubeda Ismail from University of Malaya, Dr. Ashraf Huli from University of the Western Cape, Dr. Balawin John from the Lathrop University, and two presenter, two speakers from the Faculty of Sharia Law, Professor Maskuri Abdillah and Professor Amni Lubis. The Honorable, my colleagues in Faculty of Sharia Law, all vice dean, lecturer, and all presenter and all audience. It is our great pleasure to have you all join the 9th International Conference on Law and Justice, hosted by the Faculty of Sharia and Law in collaboration with the University of Malaya, Malaysia. Secondly, on behalf of the Faculty of Sharia and Law and the committee, we would like to express our thanks to all distinguished speakers, presenter, and all audience. I also would like to personally appreciate the hard work of the all committee members, especially to Dr. Masrofa, the chief of this committee. I believe that Allah sees and appreciates your best effort to preparing this conference. The ICLJ is an annual event hosted by the Faculty of Sharia and Law. We have collaborated with various respected institutions in every conference. Also, we select a different theme every year by considering the harmonization of law in various issues in society. We know that Sharia is one of the law system in Indonesia. So we have to harmonizing the Islamic law and the another system of the law. In other words, this event is to bring together idea and thought from multiple disciplines of law and Sharia and its interaction with other disciplines and issues, such as humanity, technology, business, and etc. Furthermore, I would like to inform that one of the output of this conference is the publication in reputable journals and proceeding. Maybe this output with the article can be published in Ahkam Journal, one of the Scopus Index journal owned by the Faculty of Sharia and Law. I hope you have a wonderful and stimulating conference. It is a pleasure to have you all, and I hope that you all can meet with us in the next ICLC next year, inshallah. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much, Professor Maksum, for those warm welcoming words and for your faculty's commitment for fostering international collaboration. Okay, Professor Asep, uh, are you ready for the welcoming remark? Okay,
Mbak Aida, the Secretary
yeah,
of
Prof.
Rector, called us that the rector will deliver his speech in 9 o'clock
Thank you, Professor
because
Maksum, for the confirmation.
because
Thank you
he
so
has
much.
an activity in the Faculty of Science and Technology. So we can continue.
Okay. Thank you so much, Professor Maksum, for the confirmation. Okay, ladies and gentlemen, thank you so much for waiting. We now transition to Dr. Mashrafah SAGMSI to guide our discussion and facilitate the ICLJ 2025. Thank you so much, Dr. Mashrafah. The screen is yours.
Oke, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. Honorable the Dean of Sharia Law Faculty, Professor Dr. Muhammad Masum MINDC, and Director of UAN Jakarta, Professor Dr. Asep Saifuddin Jahar, and also distinguished guests and participants and presenters of the 9th ICLG. Good morning, everyone. Welcome to the 9th International Conference on Law and Justice. And my name is Dr. Masrofa, and I'm so honored to be your host for this event. Before we going on to the next agenda, the opening speech from the rector will be available on at 9. And I would like to inform you some kind of this international conference. First, I would like to start off by expressing my heartfelt thanks to all of you for taking the time to join us today. And we really appreciate that your participation is greatly appreciated, and we are so glad that you could be here with us today. And so once again, a very warm welcome to all of you. We hope that you find this conference both engaging and informative. And then I would like to inform you some kind of information before we get started. the rule for today's conference. The first one is please ensure that you have a stable internet connection and are in quiet environment to minimize background noise. And the second one, please use the chat feature to ask any question you may have during the event, and our panelists will answer as many as possible. And also the third, please keep all questions and comments respectful and relevant to the topic at hand. Any inappropriate behavior will not be tolerated. And the fourth, please note that today's conference is being recorded for future reference. And there are just a few guidelines to ensure that everyone has a positive and productive conference experience. And I would like to inform you also about this is the 9th International Conference on Land Justice, ICLJ. We have a theme, ethics in action, navigating legal integrity and accountability in the modern justice system. And we have also many presenters in this event, actually around 24 papers that they will be presented their paper in the break room and at the parallel session 1 and 2. And we also have distinguished presenter or invited speaker. For the first session, there will be Professor Madya, Dr. Siti Zubaida Ismail from University Malaya, Malaysia. And the second one, we have Professor Dr. Amani Lubis, LCMA from UIN Syarifullah, Jakarta, Indonesia. And the third, Professor Dr. Mashkuri Abdillah from UIN Jakarta. And after that, we will go to the parallel session 1. There are 6 breakout rooms. All the participants and presenters could join the breakout rooms, which is available on your screen after the session. And after that, at 12 until 1:30 p.m., we will have break for prayer and lunch after parallel session 1. And then we continue at 1:30 p.m. until 2:30 for invited speakers session 2. And we have Dr. Baldwin Jones from Lathrop University, Australia. And the second is Dr. Ashraf Bully from University of the Western Cape, South Africa. And then after that, we go to parallel session 2. And the participant and presenter could join also the breakout rooms. And we have so many topics from this conference, which is available in the breakout rooms. The topics talking about faith, justice, human rights, and the rule of law. And we have until 3 papers in here. Also, we have from Thailand and also from Indonesia, of course. And the breakout room 2, the topic is the bureaucratization of Sharia in family law, authority, reform, and regulation. We have 5 presenters in this breakout room 2. And then the next topic in breakout room 3, the topic is gender, legal reform, and social ethics in Islamic law. We have 5 papers or 5 presenters in this breakout rooms. And the breakout room 4, the topic is adat, ethics, and contemporary Islamic legal thought. We have 5 presenters and of course 5 papers. In breakout room 5, the topic is rethinking Islamic financial ethics, legal dualism, social function, and epistemic injustice. We have 5 presenters. And the next is breakout room 6. We'll talk the topic about the intersecting realms of law, from Islamic finance to political reform and technological governance in Indonesia. We have 5 presenters. And we really appreciate to all participants and presenters who will join the break room to discuss many can issue regarding about our topic or theme of ICLJ today. And we still wait for the rector until at 9. And also to inform you that you can also join the discussion also in the parallel session. We really appreciate for that. Okay. Thank you for your attention.
Well, thank you so much, Bu Mashalfa, for the information. We took that our conference until evening. Yeah, thank you so much, Dr. Mashalfa. And we are still waiting for the rector. Please wait, and thank you so much, everyone.
Fakultas Syariah dan Hukum menyelenggarakan pendidikan bagi peminatan keilmuan syariah dan hukum. Kurikulum yang memadukan teori-teori keislaman, kemodernan, dan keindonesiaan, dosen dengan latar belakang profesi dan akademik, dan lingkungan perkuliahan yang nyaman menjadi dasar keunggulan studi di Fakultas Syariah dan Hukum.
Fakultas Syariah dan Hukum periode 2023-2027 mencanangkan 10 program prioritas. Program prioritas ini merupakan turunan dari visi dan misi UIN Syarif Hidayatullah Jakarta yang kemudian diturunkan dalam visi dan misi Fakultas Syariah dan Hukum dan dirangkum dalam 10 program utama. Di antara 10 program utama itu adalah pertama, internasionalisasi Fakultas Syariah dan Hukum. Kedua, peningkatan akreditasi program studi menjadi program studi yang unggul dan juga terakreditasi internasional. Yang ketiga, program prioritas adalah terkait dengan penguatan peran alumni yang diwujudkan dalam dua hal. Pertama, peran alumni dalam mengembangkan peran mereka untuk memberikan bantuan untuk mahasiswa-mahasiswa Fakultas Syariah dan Hukum yang kesulitan dengan mengumpulkan dana abadi alumni. Yang kedua, yaitu dengan menyusun roadmap atau peta karir alumni yang diturunkan kepada mahasiswa, sehingga mahasiswa ketika semester awal sampai semester dia akan akhir, dia sudah punya peta ke depan ingin menjadi pengacara, menjadi hakim, ataupun menjadi profesi-profesi lain sudah disiapkan bersama-sama dengan alumni. Program prioritas keempat adalah terkait dengan rekognisi publik terhadap pemikiran para sumber daya manusia Fakultas Syariah dan Hukum. Program prioritas yang kelima adalah kapitalisasi sumber daya yang ada di dalam Fakultas Syariah dan Hukum. Kita punya SDM dan sumber sarana prasarana yang kita bisa gunakan dengan kemampuan yang kita miliki sehingga bisa menghasilkan kapital-kapital di kemudian hari.
Fakultas Syariah dan Hukum UIN Syarif Hidayatullah Jakarta memiliki 6 program studi tingkat sarjana dan 2 program studi jenjang magister. Di antaranya, program studi hukum keluarga, program studi hukum ekonomi syariah, program studi perbandingan mazhab, program studi hukum pidana Islam, program studi hukum tata negara, dan program studi ilmu hukum. Untuk jenjang magister, Fakultas Syariah dan Hukum UIN Syarif Hidayatullah Jakarta memiliki Magister Hukum Keluarga dan Magister Hukum Ekonomi Syariah. Dalam menunjang kegiatan mahasiswanya, Fakultas Syariah dan Hukum memiliki lembaga semi-otonom, yaitu Moot Court Community untuk kemahiran hukum, Islamic Astronomy Student Council untuk kemahiran astronomi, serta Galeri Investasi dan Bursa Efek Indonesia untuk kemahiran ekonomi. Di samping itu, Fakultas Syariah dan Hukum memiliki pusat studi dan kajian yang dikelola oleh dosen yang merupakan para pakar di bidangnya. Pusat Kajian Studi Perundang-undangan, Pusat Kajian Studi Hukum Internasional, Pusat Kajian Studi Konstitusi dan Legislasi Nasional, Pusat Kajian Studi Hukum Ekonomi Syariah.
Prioritas Fakultas Syariah Hukum selanjutnya adalah penciptaan fakultas hijau atau Green Faculty dan penguatan suasana keagamaan. Kita ingin menjadikan fakultas ini adalah fakultas yang bersih, fakultas yang nyaman, dan fakultas yang sehat dengan menerapkan Green Faculty. Selain itu, kita juga ingin menciptakan suasana religius, keagamaan, sehingga menjadikan fakultas ini fakultas yang tenang, fakultas yang menenteramkan hati kita semua. Program prioritas yang ke-10 adalah tata kelola yang bagus dan peningkatan kualitas serta modernisasi sarana prasarana yang dimiliki oleh Fakultas Syariah dan Hukum. Target dari tata kelola yang baik adalah birokrasi kita adalah birokrasi yang melayani, berintegritas, disiplin, dan keterbukaan, sehingga mahasiswa dan sivitas akademika mendapatkan layanan yang cepat, yang mudah, yang baik. Begitu juga dengan sarana dan prasarananya. Kita akan lakukan modernisasi sesuai dengan perkembangan teknologi, informasi, dan juga kebutuhan dari sivitas akademika Fakultas Syariah dan Hukum.
Program studi yang ada di Fakultas Syariah dan Hukum, baik jenjang sarjana dan magister, dicanangkan memiliki akreditasi internasional. Hal ini ditujukan untuk menunjang keahlian, kompetensi, dan daya saing seluruh sivitas akademika Fakultas Syariah dan Hukum dalam mensukseskan kurikulum Merdeka Belajar Kampus Merdeka. Akreditasi internasional menjadi satu instrumen penting pada cita-cita UIN Syarif Hidayatullah Jakarta World Class University. Capaian dalam bidang administrasi berupa transparansi, pengelolaan sistem tata usaha, Fakultas Syariah dan Hukum mendapat predikat ZIWBK atau Zona Integritas Wilayah Bebas Korupsi oleh Kementerian Agama. Hal ini menjadi wujud clean good governance telah sukses diselenggarakan di Fakultas Syariah dan Hukum.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Saya Dr. Wahiduddin Adam SH MA. Sekarang saya menjabat Hakim Konstitusi pada Mahkamah Konstitusi Republik Indonesia. Saya menjabat Hakim Mahkamah Konstitusi sejak 21 Maret 2014. Saya adalah alumni Fakultas Syariah IAIN Syarif Hidayatullah Jakarta.
Assalamualaikum warahmatullahi wabarakatuh. Saya Mas Kuri Abdillah, Guru Besar Bidang Hukum Islam atau Fikih Siasah, Fakultas Syariah dan Ilmu Hukum, UIN Syarif Hidayatullah Jakarta. Jadi saya kuliah di IAIN Syarif Hidayatullah Jakarta itu hanya 2,5 tahun dari tahun 1983 sampai lulus 1985. Demikian saya kira yang bisa saya sampaikan. Semoga bermanfaat. Wassalamualaikum warahmatullahi wabarakatuh.
Masih banyak lagi.
Okay, very sorry for wait. And then for the next agenda is invited speaker session 1. I would like to invite Professor Dr. Amani Lubis LCMA from UIN Syarif Hidayatullah Jakarta. Before the presentation from Prof. Amani, I would like to read the curriculum vitae or profile of Prof. Amani. Prof. Amani Lubis was born in Cairo at 22 December 1963. Professor Amani Lubis got her undergraduate degree from English Department at Al-Azhar University, Cairo in 1988. She obtained her master's degree in 1993 and doctorate in 2002 from Syarif Hidayatullah State Islamic University, Jakarta. Major field of interest, Islamic history and civilization, Middle Eastern studies, Islamic political thought. Side field of interest, religious studies, Islamic history in Southeast Asia, Islamic education, social and gender studies. And since 2019 until 2023, as the rector of Syarif Hidayatullah State Islamic University, Jakarta. Since 2003 until 2009, as the Vice Dean of General Administration of Faculty of Islamic Studies, UIN Jakarta. And also a lecturer of UIN Jakarta, lecturer of graduate program at University Indonesia and University of Defense. In 2011 until 2013, Deputy Director of Institutional Development of UIN Jakarta Graduate School. In 2009 until 2012, external examiner for MA thesis and PhD dissertation in University of Malaya, Malaysia, and visiting professor at Ibnu Tufail University of Kenitra, Morocco, since October and December 2015. And 2029 until present, member of the academic state, Muhammad bin Zayed University for Humanities, Abu Dhabi, 2021, until present as a member of the Afghanistan Indonesia Women's Network, and since 2018 until present, member of the Fatwa Council of the United Arab Emirates, Abu Dhabi. To Professor Amani Lubis, the screen is yours. Okay. Okay.
Thank you very much. Thank you, Ibu Dr. Mashrafah. Thank you for the organizer to invite me to this distinguished international conference. Alhamdulillah. So, thank you for the introduction also about me. And I'll talk in English. I prepare my presentation in English, and hopefully there will be some insights to be quote from this conference, inshallah. Thank you, and I would like to greet the Dean of Faculty of Sharia and Law and all of the distinguished speakers, and I also greet the Professor Mashkuri for his speech. Alhamdulillah. Thank you very much. And of course, Ibu Mashrafah did a lot there for making this conference available. Alhamdulillah. Thank you. And the Dean also. The topic of this of my presentation is about the conference. The main theme of the conference is about ethics in action, navigating legal integrity and accountability in the modern judicial system. I hope my presentation also heard by the distinguished speakers from overseas so that they can have an overview about the judicial system in Indonesia. Yeah, ethics as moral principles in modern legal system. It's the foundation of the modern ethics is the foundation of the modern legal system. Why is that? Because ethics is not positioned as a complement to law, but as a constitutive dimension of the existence of law itself. In Indonesian context, the increase in public expectations regarding the quality of legal justice is demonstrated in various national surveys that record as increase in public awareness of transparency, fairness, and accountability in the legal process. So we can consider Indonesia as a laboratory for using or for promoting ethics in modern legal system. I believe that because we have Pancasila, we have all of the Islamic principles about Sharia, and also Indonesia is considered as a laboratory for harmony, unity, and Indonesia also harmonize religious matters, religion, and the state law. So legal ethics also provides an entry point for a more inclusive and contextual approach to law, especially in responding to the needs of vulnerable groups, including women and children. Legal ethics in the Islamic perspective is not separate from the substance of law itself, but rather becomes its driving force. So the Maqasid Sharia here is important because the Maqasid approach is not only ensured the law has a normative basis, but also ensures that law brings real benefit to the harmonious life in society. Yeah, sorry. Sharia is not merely seen as a formal normative device, but as a manifestation of divine will aimed at realizing justice, mercy, and the welfare of humanity. Therefore, Islamic legal thoughts is rich in ethical approaches from that form the basis for the development of a moral and humane legal system. The values like al-adl, adala, justice, maslaha, interest, and also amana, trustworthiness, form a triad of Islamic legal ethics that not only function as normative moral principles, but also as the foundation for building a national legal system that is inclusive, sustainable, and responsive to the needs of the time. The Pancasila-based ethical approach provides a balance between the universality of rights and locality of cultural values, thereby addressing legal needs in a contextual manner while maintaining high moral standards. In a global context, increasingly polarized by identity politics and the clash between legal formalism and moral relativism, Indonesia's legal ethical approach rooted in Pancasila, Maqasid al-Sharia, and universal human values can serve as transformative model for development a civilized legal system. As we know that Indonesia tried to implement good governance, so that it's obvious also from the legal hierarchy in Indonesia. We respect and we implement all of the articles of the Constitution, our Constitution, 1945 Constitution, and there are hierarchies in the legal system in Indonesia. The decrees that we respect, decree of the People's Assembly, of the Parliament, and also there are also presidential regulations and regional regulations, and so all this hierarchy made the Indonesian people have their protection from the government and also from the legal system in Indonesia. So accountability, I saw it in the legal system of Indonesia is the important annual report of each governmental bodies and also all of the organization in Indonesia. We follow the report, very subtle report from the all in governmental organizations and governmental bodies like LAKIP. LAKIP, it's a report that should be implemented, should be issued by all international, by all national bodies, governmental and non, especially governmental and its bodies. Yeah, so there is for integrity now. In legal integrity is a key informant in building and maintaining public trust in judicial institutions, and in turn strengthens democratic stability and clean governance. In Indonesian context, strengthening integrity of legal institutions has been an important part of a national legal report agenda since the Reformation era, 1998. So one concrete step in strengthening integrity is through regulatory reform and judicial system restructuring. For example, the Supreme Court, Mahkamah Agung, has continuously issued various internal regulations such as Supreme Court Regulations, Peraturan Mahkamah Agung number 7 year 2016 on the enforcement of work discipline for judges and judicial officials, followed by Peraturan Mahkamah Agung number 8 on internal supervision handling public reports. These regulations affirm that a systematic commitment to build internal integrity through discipline, professional ethics, and measurable and fair oversight mechanism. The modernization of judicial system is no longer sufficient to rely solely on institutional reform and personal ethics, but also requires systemic innovation using AI, using applications, using technology, so that it can bring justice closer to the community and a more inclusive, efficient, and transparent manner. Yeah. The transformation in Indonesian legal system, there are 3 levels of transformation. Yeah, let me see. There are 3 levels of transformation in Indonesian legal system: structural changes in bureaucracy. The legal system needs to encourage constructive public participation, not only a watchdog, but as an ethical partner from within the structure of modern judicial system. And second, functional changes. Along with the increasing public awareness of their rights and obligations as citizens and community, it's necessary to change the strategy of providing services to the community. One of the important strategies is to empower the service. Public ethics-based legal education, legal clinics, and capacity building for the legal community are important to broaden the understanding that law is a shared responsibility. The third transformation is cultural. Leaving old habits that are no longer in accordance with the times, trying to reach the deepest depth of the heart to be willing to accept changes offered, and how incorporate patterns, a new thought in accordance with principles of Pancasila. The values of Pancasila are compatible to Islamic ethical principles, and from the culture, from the custom of Indonesia, the custom of the people of Indonesia also, we had these ethical principles such as justice, honesty, keeping promises, piety in the administration of legal power. Now, how we say that accountability of legal institutions realizing a responsive and open system. So how we create accountability as an open system? So we should first to train and to be competitive and adaptive. Adaptive human resources such as professionals, experts, technicians, and managers of legal institutions, so that transparency and accountability, as we call it in Islamic tradition, there is muhasabah and mas'uliyah, is not encompasses procedural openness, such as the publication of decisions or annual reports, but also reflects the commitment of legal institutions to make justice a process that is accessible, understandable, and also accountable to the public. And then accountability can be seen also in the reports, like I said, like LAKIP, and this is one of the principles of good governance, which places the legal system as one of the main elements in strengthening democratic institutions, protecting human rights, and also it showed that the performance of the legal system in Indonesia is getting better. And how to improve the accountability? So we consider it not just procedural, but also substantive accountability requires integration between reporting system, ethical culture, and social responsibility. Yeah. So I'll discuss now about gender because this is my duty to respond, to talk a little bit about responses to gender issues, inclusive and fair legal ethics. So gender issues is the legal system. In the legal system are not merely a matter of statistical representation, but also concern access, substantive justice, and also protection for vulnerable groups such as women. In the context of modern state based on the rule of law, equal access to the law and legal protection for women are important indicators of the success of the legal system in carrying out its ethical and humanitarian functions. Women face structural still, yeah, we in this era, women face structural and cultural barriers in assessing justice, include discrimination in legal proceedings, a lack of understanding among officials about gender-based violence, and limited access to legal protections that is sensitive to women experiences. Yeah, to address these issues, the state has taken concrete steps through various legal policies. One significant achievement is the enactment of law number 12 of 2022 on sexual violence crimes, Undang-Undang TPKS, which provides comprehensive protection for victims of sexual violence, including the right to rehabilitation, restitution, and protection from re-victimization. In addition to normative protection, access to the law has been strengthened through the establishment of women and children's service units under the police institution, as well as the establishment of legal and human rights service spots in various regions to facilitate marginalized groups, including women. Yeah. So what's about morality? Morality in legal system, as I can summarize, is especially in the legal system as an expression of nations' integrity and responsibility. So our duty is very important and very difficult. Yeah, to strengthening the accountability of legal institutions needs to continue to be directed towards three main strategies. Three main strategies is institutionalizing transparency that balances openness and stability. Second, internalizing ethics into legal education and training on an ongoing basis. Third, institutionalization, sorry, institutionalizing spaces for dialogue that enable the community to be part of the formation and supervision of public ethics in a constructive manner. So in conclusion, I would like to emphasize that a just modern legal system cannot be separated from an ethical foundation that upholds human dignity, equality, and accountability. Islamic values in the form of hisbah, muhasabah, can be can serve a normative inspiration for creating a legal accountability system that is not only legalistic but also highly moral and socially just. This is Islam's contribution to humanistic and ethical global legal governance. The idea of inclusive legal justice cannot be separated from its underlying values. In Indonesian context, for example, which is characterized by religious and multiculturalism, Islamic values provide a strong ethical contribution to building a legal system that promotes equality, humanity, and substantive justice. Substantive justice cannot be achieved through superficial legal neutrality, but rather through a commitment to social context and experiences of vulnerable groups, such as women and others who face injustices. Inclusive legal ethics is ethics that has the courage to listen to and understand vulnerability. Along with the acceleration of digitalization of legal system, new complex and multidimensional challenges have emerged. Among the most fundamental are issues of personal data protection, ethics in the use of artificial intelligence, and the potential for systemic bias in the algorithm-based decision making. All three requires a legal response that is not only technocratic, but also ethical and value laden. Thank you very much. That's my conclusion and my insight about ethics in action, navigating legal integrity and accountability in the modern judicial system. Thank you for this opportunity, and I hope this conference, the international conference on law and justice, will be successful and give fruitful discussion to all of us. Thank you very much.
Okay, thank you so much, Professor Amani Lubis, for that insightful presentation. And I would like to make some point that you're talking about so many aspects regarding our theme today, talking about the value of Pancasila is compatible or principle of Islam, and also the accountability system protecting human rights, substantive justice, and gender issue of legal system and morality. There's a very interesting topic that we can discuss together in this event. And before we're going to the next agenda, that we still wait for the rector to give a talk in the session. And then I would like to give the opportunity for the next speaker. And then before we going on to the next speaker, I would like to make some points that Sharia, as one of the core tenets of Islam, plays a central role in the lives of the Muslim, because it provides both an ethical, moral, and legal foundation that guides daily conduct and decision-making. And for this context, Muslims often revert to their way of life through the framework of Sharia and Fiqh. And also we know that law enforcement ethics refer to the moral and professional standards that individual in legal enforcement, such as judges, police officers, and prosecutors must uphold. And these principles aim to ensure fairness, transparency, accountability, and non-discrimination in the enforcement of law. Upholding ethics standards is essential for building public trust in the justice system and preventing abuse of power. And also, I would like to make some highlight of this. The significance of law enforcement ethics can be seen in several key areas. For example, building public trust, preventing abuse of power, realizing justice, enhancing law enforcement and equality. And in response to the evolving challenges and demand within contemporary justice system, And so it's crucial to reinforce the principle of law enforcement ethics and legal integrity. And to explore these pressing issues, the Faculty of Sharia and Law of Sharif Hidayatullah State Islamic University Jakarta is proud to host the 9th International Conference on Land Justice, ICLJ, and this year's theme, Ethics in Action, Navigating Legal Integrity and Accountability in the Modern Justice System, underscores the importance of ethical frameworks in shaping just and accountable legal system into this world. And we absolutely cannot wait to dive deeper and explore this topic together. So without further ado, I would like to invite our next speaker, Professor Maskuri Abdullah. And I would like also to read the curriculum vitae or profile Professor Maskuri Abdullah. Okay. Professor Dr. Maskuri Abdullah was born on December 22 in 1958 and as a professor of Islamic law at the Faculty of Sharia and Law and Graduate School Sharif Hidayatullah State Islamic University Jakarta. And education, Dr. Phil in Islamic Studies at Department of Middle Eastern History and Culture, the University of Hamburg in 1995, Dr. Andes in Islamic Law at the Faculty of Sharia State Institute for Islamic Studies, Jakarta in 1985, BA in Islamic Law at the Faculty of Sharia College for Quranic Studies in 1981, and also postdoctoral program, Fulbright Visiting Scholar at Boston University, USA 2002, and a position as a Professor of Islamic Law, Fiqh Siyasi, at the Faculty of Sharia and Law, UIN Jakarta, since 1996 till present, and also as a Vice Chairman of Advisory Board of the Indonesian Council of Ulama since 2021 until 2025, and also the experience as a special advisor of the Vice President of the Republic Indonesia since 2022 until 2024. And also as a Rais Syuriah, Vice Chairman of Advisory Board, Central Board of Nahdlatul Ulama, NU, since 2015 until 2021. And so many publications that already written by Professor Dr. Maskuri Abdullah. Some of them is Islam Agama Kedamaian, Islam the Religion of Peace, Islam and the Ethics of National Life, Islam and Socio-Political Dynamic of Indonesia, and also Islam and Demokrasi, Respon Intelektual Muslim Indonesia terhadap konsep demokrasi. And with also honors today, I would like to invite Professor Maskuri Abdullah to deliver the presentation.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Ladies and gentlemen, especially the speakers and also the moderator of the conference and the Dean of the Faculty of Sharia and Law, State Islamic University of Jakarta. I would like to thank the committee and the Dean of the Faculty of Sharia and Law for giving me opportunity to present my paper on the development concept of security, the perspective of Islamic law. I would like to present this occasion with PPT. So it is possible for to.
Okay.
Yes, okay.
Yes, it's okay. It's already. Yeah.
Yeah, I would like to speak about security in the perspective of Islamic jurisprudence, or we call also Islamic law. And sometimes differentiate between Islamic law and Islamic jurisprudence. Islamic jurisprudence means fiqh, but Islamic law consists of not only fiqh, but also regulation based on Sharia or based on Islamic law. Security is now widely discussed topic both nationally and internationally. This is because everyone wants to live a decent, orderly, peaceful, and useful life, as well as be free from threat, intimidation, and violence. However, in the story of humankind, the world has never been free from security issues due to unjust and authoritarian government, as well as disturbances and threat from both within and outside. So there is actually a relationship between security and justice, because in many cases, the injustice condition is based on the authoritarian government. Disturbance and threat to domestic security are mainly in the form of criminal cases, hostility among citizens, or action by citizens that can disrupt public peace and order. Meanwhile, disturbance and threat from outside are mainly in the form of aggression from the countries or from other countries, or action carried out by non-state actors such as terrorists and drug network. The state is obliged to maintain the state security, or we call also national security, to protect the individual rights of citizens to a decent life, freedom, property, and honor, as well as to maintain security and order to the life of society in the state. The state also obliged to defend its sovereignty from external disturbance and aggression. Sorry, this is a movement. Disturbance and threat to domestic security are mainly in the form of criminal cases, hostility among citizens, and or action by citizens that can disrupt public peace and order. Meanwhile, disturbance and threat from outside are mainly in the form of aggression from the other countries. Concept of security. Sorry, I have a little problem with this. In line with the globalization, complex humanitarian issues have emerged, leading to human insecurity, such as human rights violation, conflict, wars, terrorism, drought, national disaster, flood, human trafficking, and the spread of disease, climate change, and poverty. The situation then became the world concerned about the need for human security and concept security, a concept that emphasizes the protection of human security and safety from unsafe conditions caused by non-military factors. This concept complements the traditional concept of security, which emphasizes military strength and state security. Therefore, since the 1990s, the concept of security is developed, especially introduced by the United Nations Development Program, as stated in the Human Development Report in 1994. Thus, the concept of security encompasses not only state security, al-amn al-watani, but also human security, al-amn al-insani, and community security, al-amn al-ijtimai. This is actually the development of the concept of security, because in the last time, the security introduced only state security. Every country is responsible for maintaining its security by strengthening its self-defense system against attack or aggression by other countries as or non-state actor that can threaten national security, such as terrorist attack and drug cartels. In this case, the state formed military force, which is tasked with upholding the country's sovereignty and defending the country's security. The state is also responsible for maintaining public order and domestic security. In this case, the state forms a policy institution which is tasked with maintaining public order and safety, enforcing the law, and preventing, detecting, and investigating criminal activities. Security and Islamic perspective. Islam is a religion that promotes security and peace. The word Islam originates from the verb salima, meaning safe, secure, and peaceful. This religion embodies the concept of safety in both the world and hereafter, fostering peace and social and integral relation. This principle of peace is reflected in the mission of Islam as rahmatan lil alamin, blessing for the universe, and in the form of mutual recognition and mutual respect between fellow humans. In the Quran and Hadith, numerous words and phrases related to security, al-amn, and a sense of security, al-aman, are mentioned in 27 places. In the Quran, the word safe has three meanings, namely amanah, trustworthy, as opposed to treason or tyranny, security as opposed to fear, and a safe place to live. From the perspective of Islamic jurisprudence, security is necessity that is critically needed by humans in their personal, social, and state lives as prerequisites for the smooth implementation of religious teaching, prerequisites for the expression of citizens' basic needs, and prerequisite for effective national development. Protection of the necessities is implementation of the objective of Sharia, maqasid Sharia, namely to realize the utility and benefit of humanity and eliminate damage. Tahqiq masalih nas wa daf'i darari anhum, by realizing and protecting the thing that are their necessities as well as fulfilling that thing that are their needs and culminant. Those necessities include the protection of religion, protection of life, protection of reason, protection of property, and protection of dignity. Human security. From an Islamic perspective, humans are God's vicegerents on earth, endowed with dignity and honor that must be respected and protected. As stated in the Quran, Al-Isra, we state, indeed, we have honored the children of Adam and carried them on land and at sea. وَلَقَدْ كَرَّمْنَا بَنِي آدَمَ. The protection of the necessities mentioned above results in human security, al-aman, al-insan, which includes security of faith, al-aman al-dini, security of life, al-aman al-nafsi, security of reason, al-aman al-aqli, security of property, al-aman al-mali, and security of dignity, al-aman al-irqi. This means that the five necessity become the basic concept for human life, human rights, and human security from the perspective of Islamic law. The 7K, sorry. Sorry, this is something. The 7K areas of threat to human well-being, economic, food, health, environmental, personal, community, and political security formulated by the UNDP are universal. Islam also recognized them as an elaboration of the objective of Sharia, maqasid Sharia. Among the most problematic issues this is problem or not? Among the most problematic issues is security from hunger and fear, which throughout human history had been key indicators of human security. These two problems arise as a result of poverty, climate change, conflict, war, terrorism, or genocide. Both of the problems are mentioned in the Quran, Surah Quraysh. So let them worship the Lord of this house, who has provided them with food to quench their hunger and secure them from fear. Alladhi at'amahum min ju' wa amanahum min khawf. Community security. To achieve human security, community security is needed in the form of strengthening social harmony and cohesion, preventing crime and conflict, and post-conflict recovery. This is achieved by fostering brotherhood, solidarity, cooperation, ta'awun, and justice al-adl, as well as building a security system that involves active citizen participation and increasing security awareness among the community. There are verses in the Quran about the common to do good and help fellow humans. Among other things, the Quran Surah Al-Ma'idah, verse 2, cooperate in goodness and truth, and do not cooperate in sin and enmity. وَتَعَاوَنُوا عَلَى الْبِرِّ وَالتَّقْوَى وَلَا تَعَاوَنُوا عَلَى الْإِثْمِ وَالْعُدْوَانِ. Jihad is self-defense. Although Islam strongly promotes peace, it also promotes the need for security defense measures in the form of war and physical punishment for certain crimes. Normatively, this war is part of jihad, which means the struggle to uphold religion with physical, material, verbal, and mental means. Jihad and an external defense and security, which is military force in facing threat of aggression from outside carried out by the state or non-state actors such as terrorist group and drug cartel. Currently, most ulama and Islamic leaders believe that jihad is defensive measure. Only the Salafi and Wahhabi group and part of the Muslim Brotherhood support offensive jihad beside defensive jihad. The opinion of the majority of ulama regarding the offensive jihad is based on an understanding of the Quranic verses on jihad by taking into account the occasion of revelation or asbab nuzul and the context of current social and international relations, which are based on coexistence and peaceful relation. Conflict and hostility still often occur in society and between countries in the world. Because of this reality, Islam justifies war in self-defense to establish and maintain peace. Domestic security and law enforcement. Law enforcement is intended to maintain social order, protect citizens, as well as prevent and restore losses to citizen, property, and non-human nature. Criminal law enforcement plays a crucial role in ensuring domestic security, as fair punishment deters individuals from committing crime. From the perspective of Maqasid Sharia, all action that demands the five necessities, whether committed by others or oneself, are criminal acts that must be punished. In addition to law enforcement against the five necessities, namely blasphemy, murder, theft, alcohol, and adultery, law enforcement is also carried out against the crime of treason or rebellion, and the crime of robbery or disband of security. But it is, we must differentiate between rebellion and criticism to the government, because many government in the world consider that criticism to the government considered as rebellion. Included in Hiraba is terrorism, which currently is considered a very dangerous criminal act because it can cause widespread fear, large casualties, and damage to vital objects, the environment, and public facilities. This conclusion, the above explanations show that the concept of security in Islamic perspective or Islamic jurisprudence is to support justice for all, human, society, and state, not merely for strengthening the power of government. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much, Professor Maskuri Abdullah, for the presentation. And I would like to inform to the ladies and gentlemen, during the presentation, you can also submit your question using the Q&A features or in chat box, which you can find at the bottom of your screen or maybe in the chat box. And our speakers will answer as many questions as time permits during the Q&A session at the end of the session. And we will move to the next agenda. It's our pleasure to introduce our next speakers, Professor Madya Dr. Siti Zubaidah Ismail from University Malaya, Malaysia. And I would like to read the profile of Professor Siti Zubaidah. Siti Zubaidah Ismail is currently Associate Professor at Sharia and Law Department, Academy of Islamic Studies, University of Malaya. She joined the university as a tutor at the Faculty of Sharia in 1992. She is the author of 4 books and more than 150 articles published in local and international journals. She's also an active speaker at the conference, workshop, and forum. In 2018, she was invited to speak at Islamic University at Maldives and in Brunei University of Sultan Sharif Ali in 2022. Apart from academia, she's also passionate about social activism. She is deputy chairman for Perantau Mahat Muhammadi Foundation, Central Committee member for Human Rights Groups, Malaysian Alliance for Civil Society in the UPR process, and committee member of Sharia Care, and NGO that work for Syrian refugees. And the education, PhD Islamic Law from University Malaya in 2005, LLM University of Birmingham, UK in 1998, MCL International Islamic University Malaysia in 1994, and B Sharia Hons University Malaya in 1992. And field of expertise and research interests about Islamic law and criminal justice, Islamic penology, Islamic and human rights. Publication, books, talking about, the title is Undang-Undang Islam Malaysia Indonesia, Kesatuan dalam Kepelbagaian Kuala Lumpur, penerbit UM. And also another book is Undang-Undang Kesalahan Jenayah Syariah in Malaysia. Siti Zubaidah Ismail, and also write the book titled Pampasan Kecederaan Fisikal Akibat Kecuaian menurut Pandangan Islam. And there's so many articles that have been written by Professor Zubaidah talking about kajian terhadap kes-kes penentuan status agama di Malaysia, Lex Prosensia, Forensic Justice and Social Legal Research Journal. And ladies and gentlemen, please welcome Professor Dr. Siti Zubaidah Ismail to present her paper.
Thank you very much, Madam Chairperson. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And a very good morning. First of all, I would like to thank the organizer for inviting me to participate in this international conference on law and justice. I hope you can hear me clearly over there.
Yes.
I've given the slide to Dr. Arif. May I have the slide, please?
Yeah. Okay.
Actually, I'm in the middle of a workshop, so
Yeah, I will share.
I'm so sorry I could not participate wholly in this conference. But I will present to the best of my ability my slide today entitled Legal Ethics in Action, Upholding Integrity Among Sharia Judges and Lawyers in Malaysia. What I will do in this 20 minutes time is to share with you a little bit of experience in Malaysia with regards to ethics for judges, lawyers, and Sharia prosecutor in Malaysia. Actually, I have no experience whatsoever of becoming judge and a little bit of experience becoming Sharia lawyers in Malaysia, where I practiced earlier during my younger days. But I have already, when I joined the academic at the University of Malaya, I being a lawyer at the same time being an academic is quite a task, and therefore I stopped practicing law in 2016. All right. Okay, next. I will share with you the slides. Yeah, the slides already been given to Dr. Arif, and then I think you can have the slides. Yeah. All right. Okay. Ethics. Nobody. It is doubt. It is no doubt at all that ethics is the cornerstone for the proper administration of justice. So when we talk about ethics, it applies to all, including people in the judiciary and also in the legal professional. Yeah? For judges, they also have ethics, lawyers as well. So Sharia judges and lawyers are expected to uphold the values of fairness, justice, and truthfulness as enshrined in Islamic teachings and code of ethics. Professor Mashkuri has already shared with us all the Islamic principles with regards to the ethics, with regards to the concept of security and so on. I think this paper, if blended together with what Prof. Mashkuri has explained, would enhance the understanding of the importance of ethics and rule of law. Okay, so when we talk about ethics, some people would say that why judges need ethics? Why judges need code of ethics? Why lawyers need code of ethics? Does it mean that they are also prone to doing something unethical? It's from that point of view, we can say, or we can from another point of view, we can say that it's not that we are saying that they are prone to unethical behavior or misbehavior, but then it is a safety measure or the control mechanism, just in case if something happened within the ambit of their performing their duty. So there is the mechanism how to do something, how to correct the misbehavior and so on. So not only judges, we also have as academic, as a public servant, as student, we have specific code of ethics that we should abide to. Yeah. Not just lawyers and judges, but also Sharia prosecutor, what we call the jaksa, jaksa or the pendakwa syar'i. In Malaysia, we call them pendakwa syar'i. They are also bound by internal guidelines, if not the code of ethics. All right. Next. So what is legal ethics? Legal ethics is a very broad definition, very broad word. What we can say is that it refers to the code of ethics or code of conduct governing the behavior of legal professionals with the purpose of ensuring justice, integrity, and fairness in legal practice. People may ask, do judges need that code of ethics? Yes, because it will be the sort of guideline to what extent they can or they cannot do in conducting or in ensuring justice, integrity, fairness, and so on. Because justice need to be seen. Sometimes we people on the ground claim that judges misbehave, judges behave like this outside of their work. Judges pergi kenduri kahwin, judges pergi terima hadiah dan sebagainya. That is it wrong to receive present from the people? Yeah, okay. So these are the things that people on the ground do not know completely where the right or the wrong. Okay. So we must differentiate between receiving gifts during the what we call it course of employment or outside the course of employment. Yeah. Kita boleh terima hadiah sebagai hakim, tapi itu ketika di luar tugas ataupun di luar bidang tugas kita. Tapi kalau menerima hadiah selepas perbicaraan, itu boleh menjadi satu yang unethical. So these are the things that we need to understand within the right context. Okay, so next. So if you look at the principle of Islamic legal ethics, I think maybe perhaps the previous speakers has already touched on the concept of justice, concept of amanah, as-sidqu, trustfulness, God consciousness, taqwa, truthful testimony, and so on. So all these would become the binding rules or the guideline or the principles that we must adhere to in performing the day-to-day basis of activities or duties. What more for judges and lawyers? Yeah. Okay, next. By understanding the principle of Islamic ethics, we also need to understand from the perspective of siyasah syariah how we as a law enforcer or judges, lawyers, and so on have that accountability to show to the public. Yeah, we as Khalifah. Yeah, the most important thing we must understand is we as Khalifah. Yeah, how do we sustain the leadership as judges? Because we lead by example. Yeah, we show the example to the people that we adhere to the principle of legal ethics. We are amanah in performing our accountability and duty, and we also do to the best of our ability to avoid corruption or abuse of power or fasad fil ard. So these are the things that enable us all, including judges and lawyers, to internally regulate ourselves from doing something that goes unethical. Okay, next. Okay, these are the other core principles as Khalifah. We have this tauhid, tauhid or the akidah towards God, that we have this taqwa or God fearing, takut kepada balasan yang tidak
Orang
baik
18 Agustus
pada Allah.
berapa
So
enggak masih ragu-ragu.
based on this taqwa,
Belum kamu ini ya,
ihsan,
dari
adil and amanah, we would be able to perform duty, to perform duty carefully in order to avoid all those mistakes or abuse of power or anything to the matter. Okay, next. Okay, on the ground, on the ground, practically, what in Malaysia we have this ethical framework, institution as well as the law. We have in Malaysia, in Malaysia or in states, in Malaysia, we have this code of ethics for Sharia judges, Etika Hakim Syar'i. We also have Kaedah Peguam Syar'i, which is a legal profession guidelines for Sharia lawyers, So they are bound altogether to this sort of legal ethical framework, and also in court, in Sharia court, they have issued practice direction or arahan amalan of Sharia court pertaining to judges, what can be done, what cannot be done, do's and don'ts, for all those related to Sharia court practice. Okay. Among the next please, what I can summarize points of ethics. Point of ethics, I think these are standard things that we have in other countries, in Indonesia as well, I think, where for judges, they have to maintain independence and neutrality. I just pinpoint some of the key issues ataupun key points of ethics for judges and lawyers. Judges maintain independence and neutrality, avoid conflict of interest, bias. If cases involving some relatives, your relative, judges must abstain from being the judge for that particular case. So this is to avoid the conflict of interest or being accused of being biased and so on. So better for judge to what we call it, to remain ignorant of that particular case because it involves the relatives, for example. So better avoid tuhmah or fitnah from the ground or from the public, because what happened in the case perhaps could influence the decision by the judge. So they have to have the treat litigants with fairness and dignity, avoid extrajudicial influences, political influence, and so on. They must be avoided, right? For lawyers as well, they have to uphold honesty and integrity in representing clients. Lawyers must not fight to win all the time. Kadang-kadang lawyer dituduh mahu menang aja, but then lawyers have to maintain that integrity, avoid manipulating or distorting evidence, refrain from conflict of interest, encourage reconciliation, mediation, or suluh, must be put in their mind that this sometimes it is better to solve a case, one particular case, for example, the matrimonial case, by using the mechanism of suluh ataupun mediation. Some lawyers they have this attitude of winning, attitude of winning. They want to mau menang aja mau menang aja sepanjang masa, maka they tend to use whatever they have in their means and capability to win the case. But the fact is that sometimes it leads to manipulation of evidence and so on. So this is not ethics, not ethical to do so. If you are only thinking about winning your client by ignoring the truth and the facts of the matter, it would in long run will jeopardize your reputation and so on. So lawyers must take ethics seriously. Okay. For example, in Malaysia, we have these cases of determination of religious status. Kes penentuan status agama. There are clients. They are like we call it saudara baru, apa dipanggil sana, bule. Saudara baru yang masuk Islam. Kemudian dia mau keluar Islam. Jadi dia pergi kepada lawyer peguam itu. Bagaimana seharusnya lawyer mengambil kes berkenaan? Adakah lawyer membantu dia untuk keluar Islam atau bagaimana? So there are point of ethics there. So lawyers, they understand that they will not help those who wants to keluar Islam, but they will help those who are confused about their religion. Confused meaning that they have been mistakenly registered as Muslim, whereas they are not Muslim. So this is case of clash of identity. They will help, but they will not help those who want to keluar Islam. So these are the matter of ethics that lawyers must adhere to and must give a particular concern about. Okay, next. Next, please. Okay, committee in action. So we have this committee in Malaysia, panel tata tertib disciplinary panel for Syariah judges under Jabatan Kehakiman Syariah Malaysia. We also have disciplinary committee for ethics yang this committee will investigate complaints from the public, from the lawyers with regards to the Sharia officers. Sharia officers mean judges lah, judges or people in jaksa from the public. Hearing cases hearing cases of the accusation for misrepresentation, breach of confidentiality, contempt of court, failure to comply with practices rule, and so on. So there are many sorts of complaints obtained by the disciplinary committee that they have to hear to perform a trial or do the investigation first before adjudicate the case. Okay, next. Okay, these are some of the examples of violation of ethics in action. For example, one case in 2017 involving Peguam Syari, one of the Peguam, one of the lawyers, who finally was disbarred for misconduct. In this case, that particular lawyers knowingly submitted falsified documents in maintenance case, case nafkah, to mislead the court and gain favour for his client, because of this suami isteri bergaduh, mereka mahu menuntut nafkah, kan, isteri mahu menuntut nafkah pada suami, so dia cuba menunjukkan bahawa suaminya bergaji rendah, tidak ada cukup duit untuk membayar nafkah dan sebagainya. So in order to menangkan, to gain favor for his client, so he falsified the documents. So this is unethical. So this is in violation or breach of the rule number 10, sub rule 1 of Kaedah Peguam Syar'i, where dishonesty, breach of court decorum, and duty of candor applies to him. And it was finally decided that his license, his practicing license was revoked. This is one of the sample. Okay, next. Another example is a case involving, next please. Just click at the 11. 11. Another example is on the can you click the slide number 11? number 11 at the slide. Okay, yeah, right. Thank you. Sharia officer, peguam for sexual misconduct in 2015. Yeah, this Sharia officer was accused of using his position to make inappropriate advances toward a female litigant in a divorce case. Yeah. So what happened that I program syariah this guy it was proven that he
I'm sorry, Mr.
did
Zubaida,
some
your
jeopardizing
voice,
position. Yeah,
clear?
yeah.
Is there any problem with your
Pardon?
signal? Okay, it's already good. We can continue. Is there any problem? Maybe with the signal or something else?
Can you? Okay, I said.
Yeah.
All right.
Okay, I can hear
I
you.
think it's okay for me
Okay.
here.
Yeah.
Okay. Can you hear me?
Yes. I
Yeah.
can hear you clear. Okay.
Okay, next, please. Okay, next. Okay, next cases with regards to lawyers, discipline for contemptuous conduct in court. Yeah. Against lawyer. He was favoritism by Syariah judge. Yeah? Syariah judge was next, please. He was alleged to have delivered a favorable judgment. Yeah. Next, please. Okay, favoritism by Syariah judge in 2021. Yeah. In 4 cases, he involving his distant relative. He make he make decision that in favor of the opposing party, citing conflict of interest. So this is very what we call it, dangerous, yeah, to the practice, judge for the practice. And he was asked to be disciplined by the internal disciplinary inquiry by the state JKSN, Jabatan Kehakiman Syariah Negeri. So you can say that judges, lawyers are not only legal, mereka adalah pemegang amanah kepada divine law, bearing a dual responsibility, not only to uphold the law of the state, but also to act in accordance with the teaching of Islam. So their action, decision, and demeanor directly affect public trust in the Sharia judiciary. So what we guess, it is the taqwa to Allah. Yeah, the fearing attitude is very important because it can be the internal and self-regulatory mechanism to prevent any breach of walaupun tapi kalau tidak ada sikap takwa, ya, hamba Allah, ada guna itu, ya, kerana apa yang boleh jaga manusia ini daripada kepada Allah. Wallahu a'lam, wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Thank you very much. Tak ada dah. Oh, tadi kata saya pukul 11.
Okay, ladies and gentlemen, and now it's time for Rector of Jakarta to deliver his speech. I would like to invite Professor Asep Sudin Jahar. It's time, the screen is yours.
Okay, thank you very much. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Honorable, distinguished, and ladies and gentlemen, audience and all speakers, thank you very much for inviting me to this international conference on law and justice. First of all, I would like to express my gratitude to all the audience and also the committee for making this international conference. For me as a rector, I welcome very much this international conference. Of course, very important to share our knowledge and also experience in law, in Islamic law, and also some public laws that we are faced very much in society in general. So the first point that this international conference that already started many years ago is expected to contribute for not only publication, but also the thought and ideas that can be shared and used by the academic and also lawyers. And in contemporary world, of course, the international conference, I mean, the law issues are very challenges in terms how that the law is faced and connected with the power and the people. In Indonesia, for example, we of course are faced to deal with the issues of family law, the issues of public law that is in almost every day. But now we need to discuss this issue, of course, in what far or in what issue, in what field that our role in society as the lecturers, expert, and so on. This one point we need to be considered in detail. And second, I also would like to expect the audiences for this international conference that we can reach these issues and our research to be used in term not only in academic field, but also it should be used in applied issues. I mean, in applied in society in general. So we try to propose how the Islamic law, for example, can be used as the solution, as the way to resolve the problem in society in general. So I hope the speakers and also this international conference can contribute very well to the academic and the practices in general, so we can expand our our collaboration and also our knowledge in this field. I would like to congratulate the committee, especially the faculty of Sharia and Law and its partners. And I hope this conference and the papers that already accepted can be published in reputable publication. And I wish this all can contribute to the humanity in general. Thank you very much again. Congratulations and enjoy your international conference. And could become a good contribution to the society. Thank you very much and enjoy your international conference. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam
Waalaikumsalam
warahmatullahi wabarakatuh.
warahmatullahi wabarakatuh. Thank you so much, Professor Asep Saifuddin Jahar, as the rector of the in Jakarta, who just delivered his speech and also opening this conference. And ladies and gentlemen, and now we are going to discussion session. We have just heard our three outstanding speakers, Professor Siti Zubaida, Professor Amin Lubis, and Professor Ashwadillah. And I would like to give the opportunity to the all participant and presenter to ask some question to our speakers. You can also write down on the chat box or directly raise your hand and speak in this Zoom meeting. Okay, there's one question from the chat box from Julie Janto. The question is, how are the mechanism for the recruitment of judges and supervision of judges in Malaysia implemented to create a fair judiciary? Maybe Professor Zubeda can answer this question.
Yes, thank you. I have answered that briefly, that we have the mechanism that are very strong and long established, with regards to the recruitment and supervision of judges in Malaysia. Public Service Department, with deals with the appointment, and then Ministry of Justice deals with everything from supervision of judges, appointment, promotion, and so on. And at the level of lawyers, we also have this Bar Council, State Bar Council, what we call it, Peguam Negara, AG, Attorney General's Chambers, and so on. So it can be said briefly that we have a very strong mechanism to cater for all that matters. Okay, thank you.
Okay, thank you, Prof. Siti Zubaida, for the response. And is there any other question from the participant? Okay. We still wait for the question from the participant. And Prof. Maskurji also has talked about the security justice system, and also Prof. Amani has talked about human security and also protecting human rights, substantive justice, and etc. This is a very interesting topic that we can discuss together. We still have around 20 minutes to respond to the question. Okay, Dr. Windy Triana, please, you can ask some question.
Thank you. Ibu Zubaida, I have a question for you. Regarding the importance of gender issue among the judges in Malaysia, to what extent that the Malaysian judiciary sees that gender issue is an important issue? Because if I'm not mistaken, compared to Indonesia, Malaysia has only chosen the female judges for Sharia court, I think 10 years ago, in 2012, if I'm not mistaken. Yeah, my question is, to what extent the importance of gender issues among the judges in Sharia court in Malaysia? Thank you.
Okay, thank you, Dr. Windy. Professor Siti Zubaida. Okay, I'm sorry, Professor Zubaida, unfortunately has just left this meeting because he has another activity in Malaysia, and maybe the question will be delivered to her through email or something else. Okay. Okay, is there another question? Maybe from the participant? Okay. Is there any other question from the participant? We still wait. Okay. Okay, one more question from Pak Helmi Yusuf, but unfortunately, Prof. Zubaida has already left the Zoom, asking about the Malaysian government is making toward worker from Indonesia. Okay, and maybe we have also still here our speakers, Professor Amani Lubis and Professor Nasir Abdillah.
Can I have question for Professor Amani?
Yeah, sure.
Yeah, actually the similar question with my question to Professor Zubaida. You mentioned, Prof. Amani, you mentioned about gender issue among judiciary, yes. And you mentioned also about legal education. Now in the Faculty of Sharia and Law, do you think it is important for our faculty, the Faculty of Sharia and Law, to have specific course on gender? Or what we have now is women protection and women and children protection in family law. Do you think it is important to have gender specific gender course for students for Sharia for the Faculty of Sharia and Law students, because they will be future judges, and I believe that the in-service training for the judges is still limited in terms of gender training. That's why we still found issues in the court decision when it regards to women and children. Thank you.
Okay, thank you, Dr. Windy. And I would like to invite Professor Amani Lubis to respond to the question from Dr. Windy.
Yeah, thank you very much, Dr. Windy and Dr. Mashrafa. This is the question. It's important. Of course, all of the students and even the lecturers, professors, all of us should know about how to protect the vulnerable people, vulnerable groups, not just only women, children, and also some other people, the needy, the disabled, etc. So I think we have done a lot in our university, in our beloved university, Sharif Hidayatullah State Islamic University, about gender issues, about gender subject matters. I remember that in 1995, I began to participate in a Center for Women Studies at our university, and we tried to study gender issues separate as a subject matter, separate than the other subject matters of the other yes other subject matters. I mean it's separate, but after 2000, I think 2000, with the help of SIDA, that's Canada, with the collaboration with Canada and McGill University. So we integrate all of the women issues, gender issues about these matters into all of the courses in our university. Not all, but some, like history, history and civilization, Islamic civilization, and other subject matters. So I think, like myself, I teach now 3 classes of course Islam and Science, Islam dan Ilmu Pengetahuan. So in this course, I put also about gender law and from the perspective of Islam and from the perspective of positive law. So I think uh, we need not a course, special course about women protection. No, but it should be integrated in all of the subject matters, all of the courses. So the students can discuss women issues, gender issues from many perspectives. That's I think that's my idea. Thank you.
Okay, thank you, Professor Amani Lubis. And is there any other question?
Can I have a question, please?
Okay, sure. Ari Baskoro, PhD from Thailand. Okay.
Well, thank you so much. Basically, this question is belong to Professor Amani Lubis, and thank you so much, Dr. Masrofa, for giving me the screen. Well, my question is about, as we know, Indonesia right now are having a very much big crisis about the LGBTQ plus phenomena. And my question is that as an expert of gender, human rights, and also the Sharia law, how are you looking the situations about the LGBT in Indonesia? Moreover, as I did the research last month about most of the time and most of the people who are doing the LGBT, 92% are Muslim. So how are you going to comment about this? And basically, Dr. Windy also already been asking, like, if is it possible Sharia and Law Faculty of Syarif Hidayatullah Jakarta try to establish the new department for, discussing and discourse about the gender and everything. So is this LGBTQ plus will also be one of the, project or, like subject to be discussed in? Thank you so much.
Okay, thank you, Ari. Okay. Professor Amani Lubis, you can also
Yes,
respond.
thank you very much. Dr. Ari, you're now you got your PhD now or not yet?
Yeah, I already got my PhD in the last month,
Alhamdulillah.
but right now I'm also pursuing my other PhD in America. So
Masya Allah.
I have to PhD.
Masya Allah. Okay, congratulations. You're very prolific. Yeah, Alhamdulillah. So about the LGBTQ, as my also my activity, not just in the on the campus, but also in religious-based organizations such as Majlis Ulama Indonesia and also other organizations, Majlis Alimat. So we consider that LGBTQ is a social disease. Like it is, or these are social diseases. So not to be deal with like a normal member of society, but they need help. Help from the health things, yeah, and also from the other things. As a democratic country, Indonesia uh, give all of the members of society their rights to live peacefully in the society. But these people, as you mentioned, that 90% of them are Muslim. It's nothing to do with religion. It's if you go to Europe, for example, it's also 90. No, maybe the employees in the offices, 70% of the male, maybe female also employees are accorded are from this community, LGBTQ. So they are maybe Christians or atheists or whatever. So it's nothing to do with the religion, but as you make your you made your research here in Indonesia, so yeah, most of the people or majority of the people are Muslims. I think we don't reverse the problems to give them yeah a wrong way of consultation, but they need consultation, they need advice, they need a solution to their condition, because also if you ask their inner part of their heart, they also refuse to be to be in such condition. So what we should do is to uh, to uh, let them have the help and consultation and return to religion, to the principles of religion, of the Islamic teachings, and to repent. Many people succeeded to do that, but also some failed, and the failed people, they gather together, they promote their ideas among society as if they are true, and they have the whole rights to be like others. But I always say that things that are wrong, it should be considered wrong, and we should correct it to be good. So the society should be aware, have awareness to deal with this kind of members of society. Thank you.
Thank you so much.
Okay, thank you so much, Professor Amani Lubis, for respond the question from Ari Baskoro. And okay, for the next question, please. Okay. Yeah, we just discussed so many interesting topics about the genders, about the actual issues from the society in Indonesia, and also, and it needs to we respond as academics and as a lecturer. This is kind of to broaden our knowledge and insight about the situation. And maybe is there any other question? Okay, Ibu Nurlaili Rahmawati. Okay, please.
I will ask to Professor Abdullah about regarding the war in the Middle East between Iran, Palestine, and
No voice.
Not clear.
Oh. Okay. Okay. Still di mute, masih di mute. You still mute.
Okay, I will ask to Prof. Maskuri Abdillah about regarding the war in the Middle East between Iran, Palestine, Israel, and America. What is our stance as academic? Thank you.
Yeah, okay. Thank you, Bu Nurlaili. Please, Professor Abdullah, to respond to the question.
Yeah, thank you very much. This is as respond to the contemporary case. Yeah, in Islam, we know that war is part of jihad. This means that jihad is not only war, but there is also jihad da'wah, jihad jihadul qital, yeah, or war jihad. And war in Islam is only for defensive measures, not offensive. This is uh, a basic teaching of Islam. So, for example, Iran in the position of defensive. Why didn't Iran attack Israel? Firstly, because Iran know exactly that war in Islam is defensive measures. Yeah, there are also some reason for the attack against Israel, for example, but like Houthi because attacked Israel in the name of uh, defensive, because in the first Israel attack firstly to Palestine. So Houthi, for example, it's only not Yemen, but Houthi. The Houthi is only a group, yeah, a group. The number of the people in Yemen about 30, between 25 and 30%, but they have power, especially because they are supported by Iran. So the missiles, for example, I think it is supported by Iran. So it is okay. This is lawful according to Islam because this is in the name of defensive, yeah, not offensive. But as I explained that according to Salafi and Wahhabi, or parts of Khawran Muslimud, the war or the offensive jihad is also lawful according to Islam. Yeah, especially according to Said Qutb. Yeah. So this is important, I think, because right now we have a problem. This is the human problem, yeah. Human problem not only for Palestine but also for all in the world. So there are some changes, especially in the United States, for example. In the last time, there is only the number of people who supported Palestine is only maybe 20% of the people. Because I was in the United States, as a guest professor there, and our student at that time said that we recognize Israel, not Palestine, because Palestine was considered as terrorists. This is in the last time because this is the influence of media and the influence politician. But right, many people, maybe according to the recent poll, maybe 50% of the United American people supported Palestine, not 100%, because there are some people in the United States, American people that still support Israel, including Trump. Actually, politically, very strong in the United States. So, for example, someone can be politician or can be academician if they are supported by Jewish community. This is very important. And the last time, many academicians, for example, cannot gives criticism to the Palestine, to the Israel on or the government policy toward Israel, because criticism was considered as anti-Semitism. This is yeah. I have some friend in the United States that I cannot criticize. I cannot criticize the Israel because it will be considered as anti-Semitism. But right now, no. In the last time, the criticism come from the Jewish people, Jewish academician, especially Jewish academician, because the Jewish people there, if they criticize Israel or American policy towards Israel, cannot be considered as Semitism because I am Jewish. So it is not possible for Jews anti-Jews. It is, but right now there are some people, not many, even not many, because until now their position, if if a politician, for example, politician or academician, if they criticize Israel or criticize American policy toward Israel, it is not possible, and it is very risky because in the future their career will be stopped. Yeah, this is according to my colleague in the United States. Yeah, so right now we witness that many people in the world, maybe most people in the world, except America, for example, I think, support Palestine. Yesterday, for example, in Sydney, in Australia, and many people and many states, many countries in the world, from France and UK and also Canada, and so and prior to that, as Spain. Spain has already recognized Israel Palestine, but as Canada, France, and also UK will recognize in the next September, in the next UN conference. Thank you very much.
Okay, thank you so much, Professor Abdullah, for the response. Okay, we still have around maybe 5 minutes more. If is there any other question for our expert speakers? Okay, we still give opportunity for participant if you wanna asking some question. Okay, Professor Abdullah just share with us about his perspective about how is the situation about democracy and freedom of speech regarding the latest issue in Israel and Palestine and genocide in Palestine. Is a very we are as a academic system disposition somehow we need to challenge how is democracy and the law in this word can be put in as one of the core to prevent any kind of conflict and war in this world. Okay. 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 Ladies and gentlemen, I think this is the end of our panel session 1, and then we can give big applause to our outstanding speakers, Professor Maskuri Abdullah, Professor Amni Lubis, and Professor Siti Zubaida Ismail. Thank you so much for having with us today, and we really appreciate for your attending here, and you just give us many knowledge and benefits to our conference. And ladies and gentlemen, now we are going to the next agenda. Before we going to the parallel session, I would like one more time to inform you that this conference will be there will be a parallel session 1 in the breakout rooms, and the presenter and the participant can also join the breakout room, which is available in the screen, and we will discuss many topics. Yeah, we have 6 breakout rooms talking about many aspects on this time, and there will be 29 papers will be presented until around 4 p.m. Okay, and after parallel session 1, we will have break for prayer and lunch, and then we will continue at 1:30 until 2:30. There will be invited speaker session 2, Dr. Balwin Jones from Lathrop University, Australia, and Dr. Ashraf Buli, University of the Western Cape, South Africa. And we hope you found the information and insight shared by our expert panelists to be valuable. We also would like to thank to the audience for their participation and interest in the 9 ICLJ. We believe that the information presented here will be beneficial to all who attend. We hope that this conference will inspire you to take action towards your goals. After this panel session, we'll move to the parallel session 1. And please stay tuned For our next speaker, Dr. Baldwin Jones from Lathrop University and Dr. Ashraf Huli at the second panel session will begin at 1:30 p.m. after break for prayer and lunch. Then at 2:30, there will be the second panel session. Thank you so much for joining us today. We appreciate your time and hope to see you again and enjoy the conference. Wabillahi taufiq hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh.
Okay, ladies and gentlemen, you can also join the breakout rooms. You can click more and there the icon breakout rooms. You can choose any rooms you want to attend. For the information, we have 6 breakout rooms. Breakout room 1 talking about faith, justice, human rights, and the rule of law. Breakout room 2 talking about the bureaucratization of Sharia in family law, authority, reform, and regulation. Breakout room 3 talking about gender, legal reform, and social ethic in Islamic law. Breakout 4 talking about adat, ethics, and contemporary Islamic legal thought. Breakout room 5 talking about rethinking Islamic financial ethics, legal dualism, social function, and epistemic injustice. And the last breakout room 6 talking about intersecting realms of law from Islamic finance to political reform and technological governance in Indonesia. And the moderator also already in the room. Okay, please join the breakout room.
Assalamualaikum, Winnie.
Waalaikumsalam, Wendy. How are you?
Good. It's nice to see you again.
Really nice to see you. So I was just listening to the music of the presentation.
It's your turn now.
My turn. Okay.
Yep.
Do you
Okay. Let's
have my
let's get started.
screen?
Yeah. Oke, Bapak Ibu kita akan mulai sekarang. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Welcome again to the afternoon session. We have here Dr. Balawin Jones, and we have also Dr. Ashraf Buli. Good morning, Dr. Buli. Dr. Buli is from South Africa, so it's still very early in the morning.
Assalamualaikum warahmatullah.
Waalaikumsalam.
Good morning. Yes,
Waalaikumsalam.
it is in the morning. It's 9 o'clock in the morning in South Africa.
Okay.
But thank you for having me. Shukran. Jazakallah.
Okay. We will have first Dr. Balawin Jones, and I will read her brief biography. Dr. Jones is socio-legal scholar specializing in family violence and access to justice at the intersection of gender, religion, law, and she is a lecturer at Lathrop University, Melbourne, Australia. And
Contribution of life insurance participants funds. All of premium insured.
Okay, and this afternoon, Dr. Jones will give an overview of her forthcoming book, Congratulations, Winnie, which confaces informal and formal help-seeking avenues for domestic violence victims in Indonesia, including via religious and criminal courts. And it will include mediation, gender-based justice, and so on. We welcome Dr. Jones to present her upcoming book. Silakan, Winnie.
Kashi. Just let me know if I should share my slides or whether you're able to.
Yeah, I can do it. I can do it for you.
In the meantime, I'll start. Assalamu alaikum. Thank you so much for inviting me to present today. I'll do my presentation in English, and then if anyone has any questions, I'm happy to take those in English or Indonesian. So, as many of you know, the Indonesian government passed Law 23 of 2004, the Indonesian Anti-Domestic Violence Law, or Penghapusan Kekerasan dalam Rumah Tangga. So, my book, which you can see the cover of on the slide, is coming out in November. And this book is it's based on my PhD, and it's based on about 5 years of research conducted throughout Indonesia with a case study in Aceh province. One of the interesting things about the research that we've been conducting across Indonesia in the family violence space is that the anti-domestic violence law, and I'll just go to the next slide, is over 20 years old, right? So I wanted to relate this to the next slide and also to the theme of the conference, thank you, Mindy, which is accountability in the modern justice system. So if we're talking about a law that was passed in 2004 and is over 20 years old, and we're talking about the difficulties with respect to access to justice, and we're talking about the lack of implementation of the promises in that law, I guess my question is then, where is the accountability? Where's the accountability for the system that has made this law? And, all things considered, it's a great law. But what about the implementation? And what we have is a track record over those 20 years of essentially very poor or very minimal implementation across the provinces of Indonesia. And there just remain so many substantial barriers to the implementation of the law, which, if we're kind of talking more directly, more langsung, what we're seeing is a lack of protection of domestic violence victims and widespread impunity or lack of accountability for domestic violence perpetrators. So that's what we're talking about today. And in my research, I interviewed, commissioners from Komnas Perempuan, and they were the first to say that the law is not fully operational either nationally or across the regions. So it's very well known that the law is not being implemented the way that it should be. And that brings us back to the question of accountability. So domestic violence, if it comes to one of these systems that you can see on the slide, so through the Pengadilan Agama, which in Aceh is called the Mahkamah Syariah, or the Pengadilan Negeri, that's actually a very rare occurrence because most cases of family violence aren't reported at all. And if a victim of family violence does report, they generally report at the village level. So either to a local imam or the Kepala Desa or through adat, dispute resolution mechanisms. The majority of reported cases are mediated through those adat processes. But where customary mediation fails, or where the case is especially serious, and by seriousness, that's generally assessed at the community level with respect to visual or physical violence. So in the law, there are many, many different types of domestic violence that are outlined. That could be not only violence against a spouse, but violence against children, against elders, against domestic workers, not only physical violence, but also it could be verbal violence or emotional violence, economic violence or sexual violence. And so when we're talking about cases being reported, though, there's very poor levels of understanding at the community level, but also within our institutions, of family violence as being beyond just severe visual or physical violence. And I'll talk about that a bit more later. So if adat fails to resolve the matter, then family violence cases will progress to that pengadilan agama or the civil law or religious law pathway or to the pengadilan negeri, to the criminal law avenues. And these are parallel jurisdictions with their own procedures. And that is also somewhat quite a big issue for victim survivors, because if they want to seek a divorce and they also want to report to the police, these are completely different systems with completely different procedures, and it's very difficult for victim survivors to navigate. So in the Islamic courts, that's the main place that victim survivors will seek state assistance from. So if we're not talking about informal mechanisms like the adat, if we're talking about the state and state infrastructure, then victim survivors will generally go and seek a divorce through the Islamic courts, as opposed to reporting to the police, because only in rare situations are domestic violence cases prosecuted in the criminal jurisdiction. And victim survivors who do go through these state legal avenues, like the pengadilan agama or the pengadilan negeri, then they face many hurdles. That could be community stigmas, victim blaming, but also time and cost burdens. There's very little support. Women's NGOs at the grassroots play a really big role. Also, the Indonesian Legal Aid, P2TP2A, has a paralegal program who does really incredible work supporting victim survivors. But again, funding and resourcing for those organizations is quite strained. And so they can only take on so many cases and support so many victims. But I do want to acknowledge the work of those organizations, particularly the paralegals, who are doing just such an amazing job with very limited resources. So in the book that's coming out, it basically in each chapter looks into both the literature and the data on how victims navigate these different areas of help seeking and what barriers they face when seeking help through different pathways. So, for instance, if a victim survivor does enter to the criminal or the civil pathways at the state level, then it's very common for them to face bias, misunderstandings about family violence, and also inadequate service provision.
Diisi tapi nilainya masih nol, dia ngomong begitu.
So at the village level, we know that domestic violence is generally not understood well, but families generally understand things in reference to religious interpretations. And it's only when we get into these formal state systems that we start to see any understandings of family violence that are actually based on the law. So there is still quite a barrier in terms of understanding, in terms of I guess, civic education or what's known as legal consciousness. So, what do people on the street generally understand family violence to mean? Their understandings of family violence will generally relate to religious interpretations around relationships and gender and families, as opposed to being based on the law at all. When we're talking about understandings of family violence based on the law, those are limited to when we get into higher up, more formal state-based institutes like the courts or the government. So this also operates as a barrier to access to justice for victim survivors at the community level, because community understandings of what family violence is are generally biased against women in a number of ways. So, for instance, the perception that family violence is a private problem or not a problem at all, or the justification of physical violence as being disciplinary or educative in nature. There's also a lot of victim blaming and justificatory discourses around the perpetration of family violence. And although these are most prevalent at the community level, and that means you can see them the most clearly at that community level, these biases and misunderstandings and stereotypes around family violence also influence judges and police and government workers if those state actors aren't trained or educated enough. And I also want to note that even at the community level, there are so many different interpretations of what the relevant religious or Islamic interpretations are. So it's not homogenous across Indonesia or even within families or within communities or within provinces. There's a lot of contestation, there's a lot of debate about what the correct, religious interpretation is with respect to gender and domestic violence. And most of the time we find those interpretations centered around Surah An-Nisa. So we've mentioned that the Islamic courts get most of the cases because people want to seek a divorce. The interesting thing about this is that Pengadilan Agama judges that I interviewed consistently took a passive approach and didn't directly or explicitly identify family violence in any of their decision making. This is largely because the judges felt that they didn't have the jurisdiction to consider family violence. And the book concludes that although Islamic court judges don't have jurisdiction to apply the criminal provisions under the Law 23 of 2004, domestic violence is still relevant to family court or Islamic court decision making to the extent that the presence or perpetration of family violence affects women's substantive divorce rights around property, around custody, and around nafkah. So the book argues that domestic violence should be taken into account more actively by Islamic court judges when they're deciding divorce applications. And in addition to this analysis, I analysed, and I can go to the next slide, please, Wendy. I conduct a literature review, I conduct 40 interviews with stakeholders, and I analyze 70 cases. And the cases that I analyze, because I had a lot of free time over the last 5 years, obviously, doing all of this. But this is the most comprehensive, analysis substantively of family violence in the Indonesian context because so much data was analysed to get to that point. And the 70 cases that were analysed were all from the Pengadilan Negeri. And it was so, the analysis is really rich and it's really interesting to see what kind of narratives are being considered by judges in both the determination of whether something is family violence under the law, but also the sentencing of perpetrators. So all of those decisions were analysed, and it was concluded that Pengadilan Negeri judges are influenced by gender bias in exercising their discretion when deciding and sentencing domestic violence cases. So, for example, perpetrator sentences are often mitigated based on moral, religious, as opposed to legal justifications, which leads to a failure of the court to protect women's rights and a lack of accountability for those who are using violence. And in the book, there is this analysis of those cases and the themes in those cases relating to how judges exercise their discretion. And it's shown through both the family or Islamic court analysis and the criminal court analysis that gender bias informs and produces institutional state responses to domestic violence, which actually compounds barriers to access to justice for women who are seeking support and exercising their legal rights. So overall, I conclude that the current implementation of the law, although it's over 20 years old, doesn't adequately protect victims of domestic violence and doesn't adequately deter or hold accountable perpetrators. I'll just go to the overview. That's right. The next slide. Thank you. You can see that In the second chapter, there's a case study of Aceh, which is where the interviews were conducted. And I chose Aceh because it's a regional centre. It's a centre that has been impacted by conflict and natural disaster. And it's a centre where we're seeing and have seen historically increasing Shariaization of the law. So they have that really strong Islamic interpretation at the forefront of everything that they do. And that makes for a really interesting analysis in terms of the intersection between law, gender, and religion. When I was in Aceh for those 4 years, interviews were conducted with women's rights advocates, academics, government officials, staff from frontline women's services, police, prosecution, lawyers, community leaders or Kepala Desa, and staff from frontline women's services such as Flower Aceh, and as I mentioned before, P2 TP2A. Also judges from both the Islamic court and the criminal courts. And we did a focus group with victims of domestic violence who also shared their lived experiences of engaging with these systems. Just in the next slide, what I want to talk about just before, because I don't want to go too long with the presentation, is this idea of accountability. And this is what I call the benang merah, the red thread of the book, which is about the state responsibility to address family violence and to protect women's rights. The book develops this theory of what's called bureaucratic violence. And bureaucratic violence basically means that when the state, through the law, makes promises to protect the rights of victims of family violence, but then fails to implement those rights or those protections, then that actually results in a unique form of harm, an additional harm, which I'll explain. And the book emphasizes the need for the state to be held accountable for its continued failure to protect the rights of victims and to hold perpetrators accountable. So, bureaucratic violence and the theory of bureaucratic violence in the book explains that there are provisions in the law that make so many different promises to victims about their rights, and these create correlative responsibilities on the state to fulfill those rights. But the state has failed to fulfill the promises that it's made, and this actually puts victims at an exacerbated or perpetuated risk of harm. So, for instance, there are two examples that I use in the book. One is the example of safe houses, and one is the example of rehabilitation programs. So I'll just briefly mention those. So in the law, the law makes promises to establish safe houses for victims. In chapter 4 of the law, there's a chapter called Victim Rights. And then later in the law, there's a chapter on sentencing and rehabilitation programs. And I'll just show these two quotes to give examples. One is from a commissioner from Komnas Perempuan, and she said, if we are talking about implementation, we must also talk about infrastructural support. If the police do not have safe houses, and there are no other safe houses that can be accessed, how do they practically provide protection to victims? So, interviewing people around the province, it was established that there are currently no functional safe houses in Aceh to protect victim survivors as required under the law. The head of the Bidang Perlindungan Perempuan dan Anak, she explained that it's actually common practice for women's advocates to bring the victims back to their homes to provide protection because there are no safe houses. So although the law explicitly makes a promise to provide safe houses, there aren't any. And the reason for this is because of a lack of coordination between the national government and the provincial governments. So the local and provisional government have, in fact, so in Banda Aceh as an example, allocated land and a house to be a safe house. But the national government has still not, this is 20 years later, allocated a budget to run the house or to pay staff to be at the house. So, for instance, for the electricity to be on, or for, someone to maintain the house, the budget for the operation of the house would have to come from the national government, and that hasn't happened. And the other example is of the rehabilitation programs, which are a really important part of the sentencing infrastructure. And a quote here from one of the women's NGOs is, if a husband is sentenced to go to prison, after getting out, there will likely be more violence because there is no education for the offender, and he may feel that he was unfairly prisoned. This is referring to the fact that there are no rehabilitation programs, so there's no education or behavioral change for the perpetrator to explain to them like why family violence is wrong and how you could behave in a different way. And so it's very common for perpetrators to feel entitled to use violence, justified in using violence, and to feel very angry and conceptualize themselves as the victim of violence because they've been sent to jail. And this is an example of where the failure of the government to establish rehabilitation programs directly has the result of putting victim survivors at further risk. So firstly, if there are no safe houses, then how can you physically keep a victim survivor safe? And that's not even talking about like long-term housing and the risk of homelessness for women and children fleeing family violence. But also, if there's no education or re-education of perpetrators as to why their behavior is wrong, then when they get out of jail, if they're sentenced to time in jail, then there's more likely to be more violence, which puts women and children who have reported family violence at greater risk. So these are two examples with respect to the benang merah, which is bureaucratic violence, which is what I've conceptualized in the book as the accountability mechanism that can be used to explain to government why they have to allocate budgets, for instance, or allocate resources to fulfill the promises made in the law, and why not doing so results in further risk of harm or a perpetuation of risk of harm for victim survivors. That's explained further in the book. So that's all I wanted to share, and I'm happy now. I think the next slide is the last one, if anyone has any questions.
Okay, thank you, Winnie. I will not conclude your speech, but then I will invite the audience to ask questions. It's time for you. Oh yeah. Okay, anyone with question? Okay, we have Ada and Basaria. We have two questions, and then we have very limited time. So because Winnie speaks Bahasa Indonesia very well.
Okay, thank you so much, Bu Windy dan Balwin. Thank you so much for your presentation. I think that with regards to your choice of the representative for Indonesian context. Thank you so much. Silahkan, Win.
Oke, Ibu Basaria Nainggolan.
Baik. Makasih Bu, saya bahasa Indonesia saja ya.
Oke, silahkan.
Thank you very much. Sangat menarik tadi yang disampaikan oleh Bu Materi tadi tentang Jika seorang suami, jika nggak salah ya, Prof, jika seorang suami masuk penjara ya, itu kemarin ada mahasiswa kita penelitian ya, mahasiswa S2 di lapas Ternate, saya dari Ternate di lapas. Jadi itu ada 3 kategori ya, eh, tentang nafkahnya, tentang pemenuhan nafkah ya bagi istri yang ditinggal oleh suami karena di penjara. Jadi itu ada yang terpenuhi. Yang terpenuhi itu ya karena memang istri bekerja ya, istri bekerja atau mereka memiliki harta. Tetapi ada yang tidak terpenuhi, tidak terpenuhi nafkahnya karena memang istri tidak bekerja, kemudian ya suami yang di penjara itu ya karena memang apa namanya kejahatan mencuri dan lain-lain ya karena memang keadaannya memang sudah tidak mumpuni ya, tidak eh, dikatakan tidak punya harta, akhirnya nafkahnya tidak terpenuhi. Program tadi saya juga ada eh, baca tadi waktu dipresentasikan tentang apa namanya ya apa fasilitas ya fasilitas bagi mereka yang itu kan ada program di penjara untuk apa ya asimilasi namanya asimilasi tetapi itu tidak bisa memenuhi secara keseluruhan. Bagaimana tanggapan saya panggil apa ya I call panggil apa ya untuk apa narasumber saya tadi saya terlambat ya. Eh,
It's
Ya,
Dr. Balawin. Yeah.
karena kasih ada
mm-mm.
banyak isu-isu di dalam pertanyaan
Ya.
itu. Uh, Duluan ada program di dalam komunitas tentang rehabilitasi untuk orang yang memakai kekerasan. Contohnya di Yogyakarta ada program dari Rifka Anissa. Tetapi tidak ada program rehabilitasi dari pemerintah. Juga ada program untuk dari komunitas untuk isu-isu ekonomi yang Ibu tanya, karena pasti di dalam buku saya juga ada wawancara dengan korban KDRT dan mereka bilang kalau suami saya ke penjara, bagaimana saya hidup sendiri dengan anaknya karena saya nggak bisa kerja. Dan ada banyak isu ekonomi seperti itu dan ada uh, grup-grup di komunitas yang kerja sama korban KDRT. Tetapi itu isu di dalam sistem karena hanya ada um, opsi untuk tidak ke penjara atau ke penjara. Dan bagaimana untuk korban KDRT yang tidak percaya diri dan tidak bekerja? Bagaimana
Winnie,
untuk mereka? Ya,
excuse me, we have 2 more minutes for your session.
great, great. Jadi mungkin kita perlu opsi yang lain tentang pendidikan, tentang rehabilitasi, karena sekarang untuk banyak korban-korban KDRT, mereka tidak mau laporan karena mereka nggak bisa hidup sendiri dengan anaknya tanpa suaminya kalau suami ke penjara.
And the
Eh,
second one about the Aceh, about
Bisa
why
sedikit
you
lagi
choose Aceh.
bagaimana
Oh, waktunya sudah habis, Ibu.
tanggapannya tentang apakah
Ibu?
undang-undang kekerasan terhadap perempuan tahun 2024 itu saya rasa mungkin perlu ditinjau kembali ya ya Miss ya tentang undang-undang kita itu kayaknya masih ada yang perlu karena sanksinya dan itu kan kalau melapor, kalau tidak melapor
Iya.
maka dia tidak dapat dihukum. Itu yang mungkin perlu dilihat kembali karena kekerasan ini, violence ini seperti gunung es ya yang tampak di muka saja. Padahal itu masih banyak korban-korban karena minta waktunya sedikit. Padahal itu masih banyak karena ketergantungan ekonomi perempuan tadi ya kepada suami, dia tidak berani untuk melaporkan. Itu banyak hal yang memang harus kita lihat kembali tentang kekerasan ini. Thank you very much.
Ya, pasti itu, Ibu. Dan sesi ini udah uh, tidak punya waktu lagi ya, Wendy. Terima kasih banyak untuk undangan.
Okay, thank you very much, Winnie, and congratulations for your upcoming book. Can't wait to read it. Oke, terima
Yeah.
kasih banyak, and I'll see you again. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
And you can stay, of course. We have the next speaker, Dr. Ashraf Buli. Dr. Buli, are you there with us?
I am here. Am I audible?
Yeah, yeah. Would you like to
I will
open
try
your
with my
camera?
bit.
Yeah.
Yeah, I'll try. I just had some technical difficulties.
Okay.
But let's give it a chance and see. Unfortunately, I don't think it's working at this moment, so
Oh,
I apologize for that. We've had some
okay.
technical issues this morning with it. So may I proceed, Chair?
Yeah. Do you have a PowerPoint to present?
Yes, I will put up a PowerPoint for you. I'll share it
Yep.
with you. Just give me a second. I'll share my screen. Okay. It doesn't give me the option. Just
Yeah,
tell me
it
if you
works.
can see it.
Yep, we can see it.
Okay. May I proceed, Chair?
Yes, please.
Okay, so أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم. Assalamu alaikum to everybody. And I would like to thank the Ministry of Religious Affairs of the Republic of Indonesia, Sharif Hayatullah State Islamic University, Jakarta, the Dean of the Faculty of Sharia and Law, committee members and fellow attendees. So thank you very much for allowing me to present a paper that I have completed. And the paper deals with the following issues. I don't know if you can see it right. There we go. So why Rule 43 matters, gender, justice, and constitutional rights in divorce cases in South Africa, a religious conundrum at the moment. If I could just speak on, as part of the introduction, when we look at the issue of divorce, usually it is an issue that affects a number of people within the family as well as the wider family members. And with this divorce taking place, the procedure is normally not an amicable one. It is adversarial in nature, or it results in being adversarial in nature. And as a result of this adversarial nature, it affects the children and husband and wife in this particular marriage to various degrees. It could be emotionally challenging. It could also affect them mentally as well as physically. And it is not, generally speaking, a pleasant experience. Also within a South African context, it's quite a longish period of time that elapses during instituting proceedings at that particular moment until when it culminates in the divorce being finalized. And besides the emotional, mental, and physical characteristics or consequences that flow from the pending divorce, we also have social stigma that is attached. And normally the social stigma also comes very close to heart from family members and friends, and not just the community at large. So that is just by way of introduction, and I will move on to slide 2. Okay, sorry, slide 3. There we go. So that is just by way of the introduction. And I would like to focus on the existing legal systems in South Africa. Prior to South Africa becoming a constitutional democracy, it was deemed as being a parliamentary sovereignty, where Parliament was in charge. And as a result of colonization, we had a mixture of laws. So at the moment, our mixture of laws would be Roman Dutch law and English law. And that law would be referred to as the common law or the default system, if you would want to put it that way. Based on the legal systems in South Africa, we also have something called African customary law. And here I would like to just put in a disclaimer that I'll be using certain terms that may be of a derogatory nature. However, they are not intended to be that way, just to give context to the discussion at hand. African customary law was basically the native law of the natives at that particular time, if you will, or the indigenous people that were available. And there's this robust discussion that is taking place at the moment in South Africa, looking at African customary law and living customary law. On the one hand, we have the debate where African customary law is viewed as a system that has been implemented by colonialist imperialism. And these laws were enacted just to satisfy the indigenous people at that particular moment in time. However, the new debate has come about saying that the traditional, if you will, African customary law does not recognize or go hand in hand of what is happening at grassroots level. And therefore, we have what they refer to as a living customary law. And the living customary law is actually the culture and the systems, and it's been put in place that have been practiced for many decades. So we have this current debate within South Africa in terms of the legal systems. And I think in most African states, you would find a dual legal system, a legal system that has been borrowed either from colonialists that have colonized a particular country, and you'd have then another system. In South Africa, we don't have a religious legal system. We do have religious laws in terms of the faith that the person adheres to. In terms of the religious laws would be Muslim personal law. We would also include that of Jewish religious law as well as Hindu religious law. But these laws are not codified. Now, South Africa's legal system, by and large, is not a codified system of laws. And that's very important to understand as I proceed with my presentation. So these religious laws, there's not a hierarchy in terms of which law one can prefer. And this is part of where the conundrum is at the moment. So way back in 1988, when South Africa was still very much under the apartheid regime at that stage, there was a push to recognize Muslim personal law back in 1998. But alas, that system has been very slow. There has been developments which I will allude to as I progress. So in 1988, they started this particular recognition of Muslim personal law. And why I gave the introduction speaking on divorce was that there's a vulnerable party that's at stake, and that's normally the primary caregiver. And in this instance, generally speaking, again, it is assumed that the primary caregiver would be the woman in terms of the particular marriage and going forward, the divorced particular person. So we have this particular conundrum at the moment of where do they actually turn to? And before South African's democracy, and I said that we did have a parliamentary sovereignty at that state, and like most South African states, I've said we have a pluralistic form of law. And under the apartheid regime, many pieces of legislation were enacted. And some of them were the Sexual Offences Act, the Grouped Areas Act, the prohibition of mixed marriages, as well as the Native Amendment Act. So when we're talking of, for example, the prohibition of mixed marriages, here we are saying that persons could not marry any person or cross the racial divide. So that is what apartheid was part and parcel about. Also, we had the Group Areas Act, which increased segregation at the end of the day. And all these acts reinforced a racially exclusive social order under the guise of legal and moral authority. The judiciary at that particular time had very little room to actually take on the parliamentary sovereignty at that particular state. They were very hindered in expressing themselves and the views of the many that was under this particular system. When South Africa gained constitutional democracy, and this was then since 1993 onwards, it changed into a constitutional democracy. And in the final constitution in 1996, in its preamble, states that it wants to address the inequity of the past. And how do we address this inequity and this discrimination that had taken place? So that's just the legal systems I want to talk about. And then I just briefly want to touch on our constitutional dispensation that we have at this particular moment. And with our constitutional democracy, South Africa looked at various legal systems in formulating our own constitutional democracy, obviously looking at our own needs and how to proceed forward. And what we have put in our constitution is a chapter 2, and that's very notable because it starts with chapter 1. However, chapter 2 is the most important one, and that is referred to as the Bill of Rights. And the Bill of Rights is fundamentally based on various international human rights instruments, as well as various jurisdictions taking out how we can address the past that has happened. So we have in chapter 2, we have, for argument's sake, we have the right to equality, the right to dignity, the right to freedom of religion, the right to equality before the law, which was non-existent at that particular time. So that is given a rise to my third point, and that is Rule 43. And this forms part of the uniform rules of the judiciary, started in 1965, and it has been amended since. However, what is Rule 43? And I would like to give this example because this is the first completed article I've written, Article 2, that I'm working on, I will explain later. So why did I embark on Article 43? I embarked on Article 43 because I wanted to establish, to see how this rule would interplay with the greater system of the population. And this particular example I'm giving is that this is an example of a couple married according to the Christian faith. And I'm proceeding on what it is. So this is the example that we have a couple, they are married according to the Christian faith, and it is a civil marriage. In 2025, it's a civil marriage under the new constitutional dispensation in South Africa. So Rule 43 is basically an ex parte application, and it is an interim relief. And this is the very important point. It's interim relief. It is interim relief from when the person who is launching this particular application or instituting the application during the period when the divorce has not been finalized yet. So the divorce has been instituted, it's progressing. However, the person will launch an application. I'll come to the fact who the person is. Will launch an application for this Rule 43. And Rule 43 is a system whereby a person who is in a lesser financial state as his or her counterpart launches this particular application. And in this instance, it's normally the primary caregiver. So the relief that is sought with this particular mechanism is, number one, looking at spousal maintenance during that period. Once the divorce is finalized, this interim relief then falls away, because then we have a court order that follows with all the attachments or appendices that are there. So it is a interim relief sought for spousal maintenance, contribution to legal cost, child-related matters, and custody and access to children. Now, this part is very important, which I found, because Rule 43, in a way, does connect with the Children's Act. Now, when it says there, the custody and the access to children, there's quite a number of provisions of what constitutes access to children. Bearing in mind, when I started the presentation, I have alluded to the fact that there are consequences flowing from this particular act, this divorce proceedings, and normally the children, whether they are minor or major, I think that is really irrelevant. It does affect them in some way or the other, as well as the stigma and the societal norms that are currently around. But focusing on the link between Rule 43 as well as the Children's Act, saying that you need custody and access to children. Here, I want to actually put the focus on what does it mean to have access to children? Does it only mean, and the Act makes it very clear, it says that it does not mean that you phone your children via telephone. It does not mean that. That is one mechanism that you can communicate. But you have to also have other mechanisms. You can use Skype. You have to make yourself available in terms of access. You have to then have visitational rights. You have to keep the parentalhood, or the cord, rather, still alive. Now, I said it's adversarial at the beginning because sometimes one of the parties will just cut themselves off totally because the situation has become acrimonious at this particular moment, and the children suffer. So the Act comes in, and Rule 43 makes it very clear that in granting this rule, we are also going to stipulate, and you have to abide by this particular access that's given to the children. So you have to make regular visits. You have to speak to them telephonically. You can Skype with them. You have to take them out. You still have to support them. You still have to do everything that a parent would do. It does not mean that you're getting divorced from your children as well. And I think, to me, that was the interesting part, that Rule 43 linked itself to the Children's Act and putting the best interest of the child ahead of the adversarial process that is taking place at the moment. So the considerations of Rule 43 is that there's always this uneasy or inequitable situation between, and I mean, the disclaimer is out there, between husband and wife. And normally what we find in South Africa is that the husband is more or less, generally speaking, not entirely correct, but in a more powerful or a better financial position as what the primary caregiver would be, that being the mother. And I would like just to make this example, even if they were both professionals, and there's one particular case I was reading upon where the couple, they were both doctors. However, the husband was a surgeon and the wife was a doctor, but her practice, she operated only on a half-day basis. And the reason for that was that she would take the children to school, go back to her doctor's rooms, and then leave at 2 o'clock to fetch the children and then go home. The husband on the other side was a surgeon, and he could then work normal working hours and was not burdensome or cumbersome by the fact that he had to leave his practice to go and fetch. And what Rule 43 actually says, that when you institute Rule 43 and you come to court, you have to come to court with proper documents. You have to show prima facie on the face of it that the one party has a bigger estate than what I have. And that estate has to be looked at to enable, again, the vulnerable person in this as example would be the woman to elevate it to the position of equality or equal status. So this is what Rule 43 is all about, not to lose track of the importance of the well-being and the best interest of the child. So that is when you are dealing with a couple that is of the same faith and have concluded their marriage in terms of the common law of South Africa. When I move on to point 4, which is Muslim personal law, and I've alluded to the fact that we have started in 1998 with a push to recognize Muslim marriages. And to recognize Muslim marriages because we have found that Muslim women are the most vulnerable persons in this particular marriage. And the reason for that is in terms of the maintenance and in terms of the husbands do not continue or honor their rights as being a parent. So Muslim personal law has developed in South Africa under the new constitutional dispensation, going back to 1988, then in 1993 with a white paper, and then in 1998 with a proposed draft bill, in 2003 also a proposed draft bill. And one would be thinking, well, you've had so many draft bills, why has this not become a reality if you started in 1988? And there has been major pushback from various communities on the particular bill. And I think the pushback was on the issue of that they found that Muslim law is divine, it's divinity, and any constitutional interference would be unacceptable at this particular moment. And this was the pushback from the various communities arguing this. And we had a case of the Women's Legal Center in 2022, which went to the highest court in the land, and that is the Constitutional Court. So during the period of leading up to 2022, 2023, the South African legal system had ad hoc included the Muslim woman as a spouse in various pieces of legislation. For example, the maintenance and spousal support, where they've included Muslim women, because they found that particular piece of legislation being unconstitutional. So there has been progress, but progress has been very slow, nonetheless. However, the problem in 2022 and 2023, the highest court in the land, Constitutional Court, which deals with constitutional matters, hearing this particular case, which started from the High Court and then moving to the Supreme Court of Appeal and eventually the apex court, the Constitutional Court, included, I would rather say, that Muslim marriages are now recognized in terms of the Marriage Act and also recognized in terms of the Divorce Act. Now, the conundrum now exists, and what I'm referring to is that what happens in the case where a Muslim couple have engaged two legal systems. One, let's call it the common law system or a civil marriage in terms of the law of the land, as well as a Muslim marriage in terms of religious law. So the conundrum now is, can I use Rule 43? Do I go to court, the courts of the land, and do I get my divorce there? And as South Africa, we do not have Muslim courts to adjudicate these issues. We do have certain organizations that have been here for a very long period of time, are well recognized within across the world. We have the Muslim Judicial Council that deals with personal law matters. So normally, the person who'd seek a divorce in terms of its religious obligations in terms of the Muslim Judicial Council and get a divorce from that particular institution. But my problem on the second article that I'm working on, and the example that I'm using here, is that what happens when the Muslim couple have concluded a Muslim marriage in terms of the religious obligations, and now also include or wants to conclude a civil marriage. Now, just as a point, by and large, South Africans have been free to practice their religion during the apartheid era as well, left totally untouched. And I think there was a reason for this, as well as Judaism and Hinduism. And I think there's a reason behind this, is that to keep the status quo as it is and not to create any friction with the existing laws. So I'm more of the belief that to keep those particular citizens happy, we will not interfere. So we do not have strife, and we do not have civil law ensuing because of an intrusion. But we now, in the new constitutional dispensation, we want to be taken into account. So the question now remains, and before I get on that point, the point I want to make is that for a long time, Muslims in South Africa had the option, besides recognition of Muslim personal law, had the option of actually entering into a civil marriage. And many of them have done so, but not all. And they have not done that for the simple reason is that they believe that my religious marriage is between my Creator and myself, and that is it. My Creator is called to witness my nikah, in other words. So they believe in that particular system, and they do not take it further, going to the civil courts. So the question now remains, and with this new pieces of legislation which have been acted in 2024, based on the 2023 Women's Legal Center case, where Muslim marriages are recognized as well as divorces, the question now remains is that what happens when the husband or the couple, they are married both in terms of the civil law and the religious marriage, the husband issues a talaq or the utterance of a talaq. What then happens? Is the wife then allowed to access Rule 43? Now, the conundrum here is it's based on your conscience at the end of the day. In terms of Muslim personal law, your maintenance is for 3 months during the Ida period. So I'm going to leave the Ida period. I'm not going to go to the other part of it. So that is the standard rule, that the maintenance is applicable, but it carries on for the children or whatever needs has to be addressed and stuff like that. Unfortunately, again, there are those that do not honor their obligations, and women are left in a destitute position where family members, they have to go to family members. And this is the social stigma I was referring to earlier. They have to go to family members to ask for assistance. And, the question now comes up, well, I'm also married in terms of the law of the land in the civil marriage. Can I use Rule 43? Can I make an application to court to say that this is what I want? So this is what I'm working with at the particular moment to ascertain how will this Rule 43 interplay where the couple is a Muslim couple married in terms of Muslim personal or religious law rather, as well as being married in terms of civil law. How would it then operate? What I've gathered so far is that there's a case that has just been heard now, 2024, 2025, it's just been handed down, where a particular couple, the husband issued a talaq, and the wife, during the Ida period, approached the courts for the Rule 43 application. And this is where we've had this heated debates coming from, that you should not be doing that. It is against your religion. It is against your conscious beliefs of what is right and what is wrong. And you should console yourself to that. And then there's the debate on the other side as well. Well, that may be true, but you are also married in terms of the law of land. And this mechanism is there to assist you, to make sure that you are treated equally, as well as that your children are treated equally and taken care of. So in concluding, this is what I'm currently working on as the second part to this first article, which has been completed already. So I don't know, Chair, as my time elapsed. I can't hear you.
Yep, we have like 2 more minutes for
Okay,
you
thank
to,
you, Chair.
yeah, to
Thank
end.
you.
Yeah.
Okay, thank you. So I will conclude by arguing that on the one hand, the investigation that I'm doing, the analysis that I'm doing, is to see how this interplay is going to be fair for each other. There will be a pushback from those that say, but you cannot do this. It is against the tenets of Islam. It's against the tenets of your religion, and you should not be doing that. How I'm going to answer this particular question, I think, and that is the conundrum that I'm faced with. But I also think one has to take in consideration the harsh realities in South Africa that exist. And by taking into those realities and looking at the women that are divorced and the destitute position they are in, and the children, one has to ask oneself, but is there not another mechanism that can assist them? You may argue and say, yes, well, you know what you have, like you just said now, the Muslim Judicial Council, the MJC organization, each province has one of these organizations. They can take care of them. And I would agree with that. I would. Unfortunately, the problem is that the Muslim Judicial Council at this particular moment, they cannot give a court order. So if you cannot give a court order, it cannot be enforced. In other words, it cannot be enforced through the police system or the judiciary. It is based on the person's conscience to honor his obligations towards the other party. And that's why I said that divorce is adversarial and not amicable. I mean, there are instances that it may be amicable, but I think that's the exception than the norm that actually happens in South Africa. So the question that we have to put forward is that if we are living in the land and there is a constitutional document, a democracy that is there, should we use one of these provisions in the Constitution, in the Bill of Rights, dealing with human dignity, dealing with equality before the law, dealing with access to the law? Why can't we use this? What seems to be the problem? And I think the problem, the pushback is basically that, you know, in terms of your religious obligations, one should not do that. But if you want to take it further and say, yes, in terms of your religious obligations, you should not be doing that. But then we should also say that in terms of your religious obligations as a husband, you should honor your duties. You should honor what you have. You should honor your offspring that have come from that. And unfortunately, we don't have that equality. And for many months and for long periods of time, the women are destitute. They do not get the maintenance that they are supposed to be getting. They don't get the medical benefits for their children. They do not get visitation for their children. And this all adds up to the well-being and the best interest of the child. The child starts being neglected. So I would conclude with that. So thank you very much, Chair, and thank you to the attendees. And
Thank
sorry
you,
about my
Dr.
camera. I do apologize for that.
Okay, that's okay. Okay, we have 5 more minutes for question and answer. I would like to invite the attendees to ask question, and we have 5 more minutes. Any questions? Ibu Dewi.
Okay, thank you very much, moderator. Thank you for Professor Ashraf for your nice presentation. Yeah, if I'm not mistaken, you said in your presentation that there is a personal law, a Muslim personal law, separate from civil law, like South African civil law. Yeah, the problem with marriage when there is state law and there is religious law, like in Indonesia, is the phenomena of like registered marriage and unregistered marriage. Indonesia has already had law number 1 since 1974, so it has been a long time. Yeah, but the problem of unregistered marriage is still phenomenon. You know, there are still many people have marriage unregistered, and you have law since 1960 something, I think, if I'm not mistaken. How is the problem of registered and unregistered marriage in your country? Thank you very much.
Thank you, sister, for that question. So under our existing religious law, I'm going to put it that way, rather, our religious law, the marriage is registered with the MJC, the Muslim Judicial Council. Now, recently, the president has recruited, I think, about 50 ulama sheikhs that can perform nikahs and have these marriages then registered. Before then, they were not really registered in terms of the law. They were seen as just a religious marriage and not as a civil marriage. And therefore, it is because of this conundrum that exists, or this void that exists, is that there's the push to have Muslim personal law codified or enacted, or a draft bill put in place, so that we can have Muslim marriages registered instead of being unregistered. And also we have what we call a muta'a marriage that takes place, which is basically a temporary marriage. And so we're trying to actually also put an end to that particular practice also by making marriages being registered and not unregistered. But at the moment, they are registered with the Muslim Judicial Council, but they are now, since 2022, being registered with the state, where the president has called on 50 ulama to actually officiate nikahs in each provincial area, rather, so that they can only do it, and no other ulama or sheikh that has that designation may perform than a nikah. I hope I've answered your question, sister.
Thank you.
Okay, thank you, Dr. Ashraf. That would be the last question, because we I hope we can continue this collaboration in the future. Thank you very much. And for the attendees, ladies and gentlemen, we will have a breakout session after Asar prayer. So we'll have a break for 10 minutes? No? Oh, oke. Tidak ada break. Jadi langsung masuk ke breakout room. Iya, dan jangan lupa absennya sudah ada di chat box. Oke, thank you
Thank
for
you.
all your
Shukran,
attendance.
jazakallah. I appreciate
Thank
it.
you,
Assalamualaikum warahmatullahi
Dr. Puli. Waalaikumsalam warahmatullahi wabarakatuh. Langsung, silahkan masuk ke breakout room, Bapak dan Ibu.